Okay, you said we're ready? Okay, so we'll start the Moral Character Working Group subcommittee or meeting for July 23rd. This is the chairman's report, which is got 50 minutes, probably won't take that long. 1A is the chairman's welcomes. It looks like we've got everybody here in person.
I think you said July 23rd.
January 23rd, sorry, thank you. My dyslexia is showing up early. Next is 1B, the call for public comment. Is there anyone in the public who would like to make a comment at this point in time? I don't see anybody here, so we'll go on to number 2, business. 2A is discussion of changes to the application for determination of moral character and the questionnaires. So I'll give that to you to go from here.
Perfect. So thank you so much everyone for joining us today. So just a couple of quick changes. So at I think it was the last meeting, it was just brought up that the question regarding juvenile, I think it's a convictions, was a little bit off. So we updated that language. We have it on the PowerPoint slide for you, as well as the question on the law school declaration, so the questionnaire that gets out to the schools, the criminal history, and then we mirrored that on both the employment, the employment and the personal. Just has the question part of it, just convicted of a violation. It doesn't have the further explanation, but so we did update the law school declaration so it no longer asks for arrests or the informal violation of a law. And that's something that ODC said we were able to do just as an update to the application itself. So that's already been implemented to both the hard copy application and the online application. So I don't think there's too much about that. Any questions on that? Or okay, thank you. That was all for that.
That's given your okay.
That was the big PowerPoint.
Okay. So we're going to move to the matrix, which is 2B. Business review and finalization of the moral character decision matrix. You should have 2 or 3 different versions of the matrix in front of you. One of them with yellow on them, which I gather the yellow is comments from some of the members of the working group. The middle one with the red cross out is the response we got from the staff as a whole with respect to the decisional matrix that we as a group had put together before. So I believe what the intent is today is to go through the matrix, look at the comments staff had made, comments on whether we like the comments or don't like the comments, and then move forward from there. So do you want to just kind of walk through them one at a time and see where we go?
Yeah, that works. And so we're not going to put it on the slides just because last time it was too small to see, which is why you have the printouts in front of you. So what we did is we met with all of the investigators, the supervisors, so David, myself, and Ezra, and so just asked them to look at this as if they're looking at it from, you know, working a case, as well as when they're person of the day. So that's where they're taking phone calls from applicants, hypothetical things of that nature, how they thought that would work out. So the first thing is that they had suggested, rather than saying additional inquiry unnecessary is seldom, additional inquiry seldom necessary, and the second category added maybe. So minor changes, but I guess that would impact all of the matrices themselves. So.
Yeah, and the idea there is to sort of, you know, we're going to have the disclaimer at the bottom of the page there, and probably elsewhere on the website that explains that the matrices are not binding. It's not a mathematical formula, and we thought putting in, you know, for example, additional inquiry may be necessary, sort of reinforces that point.
So as I understand it, some of the members thought that we ought to add this seldom relevant, refer to adult misdemeanors, refer to abuse code misdemeanors. Does anyone want to speak about whether that addition seems appropriate or not appropriate?
I think we put that in.
Microphone?
We put that in because we really couldn't think of a municipal violation that doesn't rise to the level of a misdemeanor that should be relevant.
And so what we tried to do was incorporate, instead of saying seldom relevant in each box, just put it in the heading of the column and incorporate it there. So, additional inquiries seldom necessary,
So,
hopefully capturing the same idea.
right, but I guess, well, we didn't understand what, we felt like throughout, like aggravating factors, we thought that was somewhat vague for people, like throughout. And to the extent that the goal of the matrix is to create transparency, like it's very easy for a decision maker to keep pointing back, well, that's an aggravating factor, but without giving the applicant really guidance as to what an aggravating factor might be. And we really couldn't understand what an aggravating factor might be in municipal violations that didn't rise to the level of what would then be a criminal conviction, either a misdemeanor or felony. And then what was also a little confusing to us when we were, and Shelley, you should weigh in, is that when we read the overall feedback from the staff, it said to take out examples, but then the examples were put right back in, so we didn't understand, like, were we not putting in examples, or are we? It was unclear to us.
I think the feedback we got from staff generally is they were concerned if there are specific examples listed that applicants may look only to the examples and not think and see, okay, well, my incident doesn't fall within those given, so I don't have to report it or something of that nature. But I think the idea was when we were going through it, if you wanted to keep the examples rather than having them in the most left-hand column, putting them in the appropriate box, so that way it gives them some more guidance, but not just all the way in the left hand where it might be a little bit confusing. I think that was a little bit more consistent with some of the other matrices as well, so.
Okay.
I do have one comment. So I understand what you're doing in terms of putting something in the heading and then not having anything in the box. I think that is, I guess that's where you want to put you're putting the examples back in. So, and I can't imagine how excessive garbage or overgrown weeds would be ever relevant. But I think if you leave a box empty, people are going to think that they don't have that. I don't know. I think it's vague to leave the box empty. So I think you should put something in the box, whether it's seldom relevant, whatever it is. However you want to, you can have your heading, and then you should put information in the box to tell people what to do. If it's blank, then I think people are just not going to pay any attention to it at all.
And they also could interpret that to mean that, there's no circumstance under which an informal conference may be needed, which is really never the case.
Right. So I just think it's better to put information in the box, whatever it is, and then leave everything else, the headings, open to interpretation.
And, to address the issue you raised about, when could excessive garbage or overgrown weeds, when would additional inquiry be necessary? Maybe, I don't know if this would be apparent without an additional inquiry, but one could imagine if it involved not something inadvertent or negligent, but, some dispute with a neighbor or something, intentional acts, sort of facts surrounding the violation that might sort of be a red flag that there might be something more going on there than just sort of an inadvertent municipal violation.
I think that's a stretch. I mean, if it's gonna be something more, it would come up as right? It would come up as
it
something
might.
more. It would be, the red flag would be that there would be,
Maybe there'd be a criminal charge or
Right.
something. It's possible.
or something more than a code enforcement.
I think I have presented an example last time of a municipal code violation, and it might be something like failure to obtain a license for your business with the city, or failure to obtain building permits, something to that effect. And if it's over a lengthy period of time, that may reflect on moral character.
So procedurally, we're kind of like, this is our last discussion on this. Do we want to basically have some sort of vote on the working group about saying we prefer to have the seldom relevant refer to adult mediation misdemeanor, in or out? How do we, as a group, give our input to staff and say we want this in or we don't want it in? Do you want to vote on it, or do we want to just say if nobody objects, we assume that's what we want in?
Caroline, should we have the vote? Or?
Sorry, can you repeat?
So Jim was just asking, because the intent is to finalize all of the wording in the boxes, we'll format it and make it prettier afterwards and bring it to the next meeting. But for the working group, you saying should we have an actual vote as to what the working group wants, or just if nobody objects, then take that as consent?
So are you voting to just receive and file this matrices?
No, so like for example, like for additional inquiry, seldom necessary municipal violations, so the recommendation from staff was about aggravating factors exist, blah, blah, blah. But then the working group, they said seldom relevant, refer to adult misdemeanor. So for example, like choosing which language to
Yeah, so
Well, my recommendation is that the group come to consensus, and maybe it is through a vote, because we should have one recommendation
Right.
from the group, one recommendation from the working group, rather than multiple recommendations, because it is a lengthy document, so. And is that the only change? I mean,
It's going to be throughout the
there'll be a bunch of changes.
So I would wait until you have
The very end.
document. Yeah, okay.
So for example, one of the suggestions was that with respect to these 3 boxes, that I think one of the suggestions was none of the boxes should be entirely empty. If someone wants to make, sorry we have to be more formal on this, if someone makes a motion that says, as a working group, we agree that none of the boxes should be empty, then that can be the position that we as a working group have made. If no one makes that motion, then it's a suggestion, staff can either accept it or not, but it's not going to be the recommendation of the working group. So does someone want to make that kind of vote? Sorry, we have to be more formal today about this, I think, so. And I can't make motions, that's.
Sure, I'll make the motion that the boxes should not be empty.
No box should be empty. Is there a second for that?
I second it.
Do we have to be formal about who seconds and that kind of stuff here or not?
No.
Okay, good.
We don't do minutes, right?
Okay, we don't do minutes, good. So, is there anyone who wants to discuss that suggestion before we vote on it?
Are we thinking of just having an NA in any of these boxes or something of that along that line? Rather than trying to come up with substantive content saying that there's nothing to say?
So what would your recommendation if we don't know what to put in the box?
Well, I guess it depends on what box we're talking about, but so in the vehicle code section, we're talking about going over to under the box where it has informal conference may be needed. There's nothing in there, so one could interpret that to mean that even though there could be additional inquiry because of a hit and run, there's not going to be an informal conference. So I think that you need to either say, we need to put something in there saying that there's going to be, this could happen or it could happen. And I agree, if it's not relevant or if there's no action or nothing that applies in that box, then it could be NA. I guess it depends on what the box is.
And a
right?
possible simple way to do it would be in that informal conference column, say informal conference may be needed as a result of additional inquiry.
Perfect.
Yeah,
Or
Tara was suggesting maybe something like as needed. It's tricky because of the mechanics of the way the table
Right.
works to think of what to put in the box, but
something along the line of I think what Meredith said. So
yeah.
as needed based on additional inquiry and totality of the case, something like that. Maybe I don't know.
Depending on other factors or something like that. Do we want to recommend a specific language, or do we want to say we just believe staff should find something to put in that box?
I kind of like what you just said about based on outcome of additional inquiry and totality of the circumstances.
Thank you.
And I guess you might want to even put, I don't know, no, don't put that. I would say, as you use discretion in there, but I think that probably leaves it vague enough.
Okay, any other, go ahead.
And you are gonna leave the examples in, right? You just moved them in somewhere else, correct?
We haven't really got to that motion yet.
Oh, okay.
That'll be the next motion. Okay, so we've got a motion and a second, we've had some discussions. Anyone want to talk about more?
I have an additional question. For aggravating and mitigating factors, are we still talking about segmenting those out separately or leaving this column?
So that was one of the recommendations from staff. They just felt with how the table is made for, since the aggravating and mitigating factors are the end, that it might, I don't know if it wasn't, can you recall, was it that they didn't think it would draw the eye, or it was just a little bit confusing, whereas, like for an example with, I think the respect for and obedience to the law, they just had one list. So I thought, and throughout, there are a lot of them that apply to multiple cases, so rather than having to repeat it, just pulling them out, having that separate document, and so that way they can see it, it's in front, it's not just kind of off to the side. I think that was the thought behind it.
Yeah, you know, because it's always, for every one of these, pretty much respect for and obedience to the law, you know, repeated pattern and things like that are always kind of mitigating or aggravating.
So just for, I agree with that, and for point of clarification, then when we're talking about not leaving any boxes empty, we can discount that column.
Yes, so we'll go ahead, and if the working group agrees, then we'll take that column off, we'll just have an attachment on the back that has all of them.
Will there be, could there be some kind of, I worry that it not being in the column also will minimize its importance. So can we somehow signify, or in the same way that you have a caveat at the bottom that sort of says that this is guidance, but we can deviate from this guidance, can there also be some kind of language that indicates that the aggravating and mitigating factors are taken into consideration into all of this? I just worry that if it's not up at the top, then it feels very black and white to people.
I think if the working group wants to pull it out, we can definitely add that language in, so it's really up to you all if you'd like to do that or if you want to keep it on the side, so. And if we do keep it on the side, I think what we would do with the criminal part is, maybe just merge all of the cells or something. We'd have to figure it out how to do it formatting wise, but.
That's a good idea, merge all the cells, so it's just, you're just saying it one time.
I believe as we go along, we're going to be talking about sample language, applicable case law, and things like rehabilitation and remorse. So that'll be on the meeting later today, what may be in there. So back to our initial motion, second. With respect to every box should have something in it. And, Tara had some example of language which I think sounded good. Is there any further discussion on that particular motion? So, all in favor?
Which most,
Okay.
I'm sorry.
Motion to have every box should have an entry in it.
Oh, yeah.
Okay.
I think I will.
So respect, yeah. To that motion, is there any further discussion? Okay, all in favor?
Aye.
Any opposed? Okay, so we have that one. So now, the second question that came up, this will go faster hopefully, are the examples, we're looking at municipal code violations and vehicle code violations on page 1 first, are they going to stay in our recommendation for the matrix or not? I think Larry asked that question. Does someone want to make a motion whether they should stay as they're here or they should change?
I would make a motion that they should be in the matrix, maybe not on the far left column, but interspersed between the various columns, second, third, or fourth column,
As they are in the,
as they are in the document that has the red but not the yellow.
It's the staff feedback.
It's just staff feedback, yeah.
okay. So we have a motion that they be in there I don't know how we're going to call these. We call the staff feedback matrix?
Yep.
Okay. Is there a second for that motion?
I think, hold on, I think you're talking about the one that's like
This one.
22 pages.
You know, there's Okay, the one that's got the yellow, the title is wrong, frankly. It should be committee member or working group member. That's what that is. And the other one is just.
Yeah, there's a blank one. That was the one we started with. Then there's the one with the red track changes, that's staff feedback. Then there's the one with the yellow highlighting, and that has the feedback from Judge Torrialba.
Okay.
So we're, Debbie, you're talking about the 22-page one that's correctly labeled staff feedback.
I'm saying that, yes, that in the way that it includes some examples on columns 2 and 3, but not on column 1, that feels appropriate to me.
Okay, so that's the motion. Does anyone want to second that motion? We have a second. Does anyone want to discuss that motion further? Having heard no discussion, all in favor? Oh, no, I'm sorry, I didn't mean to cut you off.
It's related. I would recommend then that in this language at the bottom of the matrix, it does say that the matrix doesn't include an exhaustive list of issues relevant to determination. I do think we need to reference examples as well, just for an applicant, so an applicant understands this is not just the issues, but the examples are not exhaustive.
Just put issues and examples.
Yeah.
I think that's a good idea.
Okay, so is that a proposed amendment to the motion?
You might even want to hold that sentence.
So is that an amendment to the motion that we add it and bold it?
Yes.
Okay, is it, did whoever made the second, do you approve that?
Yes.
Sorry, the formalities. Okay, any further discussion?
I just have, I don't know if, and in the box you could say, if we're gonna keeping the examples in, it would be included but not limited to, right? And then you're double highlighting it.
So that's another amendment to the motion.
Sorry.
Does that second approve that amendment? Or does the person make the motion approve of it? Debbie, that's okay, we add that to your motion?
Yes.
Okay. Sorry, we have, the second approves that.
Yes.
Any further discussion? This is a great discussion, so I don't want to cut it short, but I want to go on with 3 or 4. All in favor? Okay. Thank you. Any opposed? So that gets us through,
Do the aggravating and mitigating factors.
oh yeah, so I guess the next question we talked about was whether we wanted to get rid of the column called aggravating and mitigating factors and instead put a second footnote at the bottom of the first page of the staff feedback matrix we're looking at. Does anyone want to just discuss that or make a motion with respect to that column?
Well, I have a question. So in other words, instead of the column, you put it at the bottom, you're saying?
Or what Judge Torrialba, or what Tara suggested and the judge agreed with, which was to combine the cells into one list that runs down as the final column.
Oh, I see. In other words, instead of separate rows, it would just be one.
Yeah.
And so each
That way,
value would have
Yeah,
its
this
own.
raises a question. When you do these kind of, is there, I assume the bar has like a department where there are people who know how to do graphics that could look at this and say, you know, this is unreadable, let's redesign it?
yes.
We have a communications unit, so that's why, so once we finalize the language itself, we'll make it compliant with, we have a state park style guide, we have to do certain things, and then, but before anything goes public, we also still have to run it by communications, and they look at it too, so.
Okay, yeah, because something like this is, because it's so complicated, you know, it's like the medium is the message, as Marshall McLuhan said. In other words, the way it's presented could have a big impact on how people understand it. So it's really important because it's so complicated with all these boxes. So I think it's really critical that somebody with an eye, a graphics person, looks at it and says, you know, maybe it might be better if you rearrange it or something.
That's a good comment.
So regarding the, having it all in one cell, I think for, the legal, the law part of it, and I'm just calling it law because we also have conduct and other, violations that have aggravating and mitigating factors. I would say if we're gonna do for one box for all the cells, to say at the top that this applies to municipal violations, vehicle code infractions, list it out at the top, even though there will be no lines. It should visually say that, but I would say it at the top also, so there's no,
Make it clear.
make it clear, so there's no room for interpretation. And then, I don't know if that works for the other areas or not, but I think it would work well for them.
I think generally, they kind of mimic one another. There are a couple one-off situations, but I think for each table that would work.
Right, so maybe we could come up with generic enough for all of them and say it applies to everything at the top, that's fine. Then you could just put all of everything that's been stated, just condense it all down and do one box and put aggravating and mitigating factors applicable to all boxes, all areas, all considerations.
Would we want to change the word from defendant into applicant?
Yes,
Age of the role of the applicant, age of the
Yes.
applicant?
yes,
That makes sense.
yes.
Okay, go ahead.
So on that list, I don't know if this is the appropriate time to talk about substantively an edit that the staff made to the list.
Yes,
Is
I
that-
think so.
Is this the time to talk about that?
Yes.
So they took out social factors of the applicant, and I was curious about that. Because that is typically in the decision-making that happens around like parole release and things like that, we do look at, did someone grow up in foster care without a parent, without sort of
Is
the
that
sort of
looked at?
stable childhood that one might, was someone sexually abused for most of their life, and then there's a reason for the patterns of behavior that that the person has engaged in. And yes, that is absolutely what a parole board would be looking at.
Okay, the reason I asked, and I'm totally familiar with what you're saying, and it brings me back to doing capital habeas work, which was all about mitigation. And in that context, I can understand how that's obviously mitigating. In this context, what the court cares about is the conduct, not necessarily why the conduct is occurring. So for example, there are California Supreme Court cases that say, if the conduct is due to a psychiatric condition or something, that doesn't negate it with respect to the consideration of the conduct in the context of a moral character determination. Do you understand the distinction?
I sort of do,
that I'm
but I
getting
don't
at?
really agree with it at all. I think it, we look at DUIs and then we say, we ask that person to then go to substance abuse treatment because we understand that they have a substance abuse issue, and then we overcome that.
Right, exactly. And so hopefully it won't reoccur in the future because they've received treatment.
Right, it's hard to receive treatment for the trauma one has, through a childhood of being neglected or abused or things like that.
That's
And I think
exactly.
that's difficult to, I just feel like there are reasons why, it's not surprising that more poor people are in the criminal justice system than affluent people.
Right.
And so I think there has to come a time where we, I'm not expressing myself very well right now, but I feel pretty strongly that social factors should be something that are considered when you're looking at the totality of someone's experience. And I appreciate what you're saying, David, about what the court has said, but I guess I just don't buy it.
Yeah, and I don't know, frankly, I'm probably
And
not.
quite frankly, there just isn't a lot of case law on this stuff.
Right.
So we're going off nothing. And we have, I think, some better understanding now than we did 20 years ago about why people do things. And looking at patterns of like, well, every single woman who's in the criminal justice system is a victim of sexual or physical violence.
Sure.
Wow, that's interesting, actually.
And so those social factors, and I'm probably not being very clear, by the way. I think what you're saying, what I totally agree with, is they go to the issue of culpability, responsibility for having committed a certain act of misconduct, but they don't mitigate the danger or the likelihood of the misconduct reoccurring in the future, which is what the issue is during a moral character determination. It sounds like a lack of compassion, but it's really sort of two distinct issues. At least that's my interpretation of what the court has said, to the extent that it has addressed these sorts of issues.
I agree with you, David. I think in the moral character context, the focus is more on if there has been with bad conduct or conduct which constitutes bad character, the focus is more on the rehabilitation, because that's when the burden shifts to the applicant to show.
Except for that we don't really give people, I'm sorry, I'm being a little bit, maybe obnoxious or pushing back a little bit.
Absolutely not.
Pushing back a little today. I just don't think we give people the opportunity to rehabilitate. Like, so they go to prison and they don't actually get any kind of trauma-informed care that like deals with the fact that they were physically abused for most of their life. So how could we then put the onus on them to have gotten rehabilitation before they apply to the bar? Do you understand? I just think, yeah, if you're rich, you can afford it. Your parents can buy you that treatment. If you're poor, you can't. You're reliant on whatever the criminal justice system offers, which, quite frankly, isn't very much.
And often you don't even know better. You're not aware of options. You know what's really interesting? I'm sorry. You are absolutely right. And what's interesting about this whole thing is, I'm sitting here saying, man, the people that are deciding whether or not somebody has moral character, are they qualified to make those kind of decisions? It just blows my mind that.
Well, and I think that's
You know.
the entire, or that's one of the fundamental purposes of this working group, is to make these decisions less subjective on the part of the decision makers and more objective, that is following California Supreme Court precedent and to a lesser degree perhaps the State Bar Review Department precedent. And addressing again the mitigating social issues when it comes to culpability, if what one is saying is that because of these social issues that existed, this person is more likely to commit what in this context are referred to as acts of misconduct, it cuts the other way, right?
And I think, sorry, I was just gonna say, I mean, the staff provided the feedback, but it's still ultimately gonna be up to the working group, so, I mean, it seems that Debbie and Larry feel strongly about keeping it, so maybe that's another motion to keeping it or not. So this, I mean, what staff provided is by no way binding on the working group, it was just the feedback that staff was providing.
So,
I would be curious what that other.
I agree with you. I think if you get an applicant who basically grew up in a gang environment where you were expected to steal and you were expected to do other things, and you did do that, but you got yourself out of there and got to basically what most people would consider to be a normal life, that's a significant change to me. So I think looking at where you were when you committed the offense is important to look at rehabilitation. So I think it should stay. So I agree with you on that point. But maybe other people have different points of view. If not, we can have someone bring a motion to say that should be added in.
I just wanted to say that I've noticed that my own personal feelings on issues like these have been changing over the past couple of years, and especially over the past few months. It seems to me that the courts take into consideration social reasons for things that happened that were bad, but only during the sentencing phase of criminal trials, and to some extent, or to a large extent really, What we're talking about when it comes to the licensing of lawyers is different than that. We're not talking about putting someone in jail. We're talking about whether or not to give them a license to practice. And it seems to me that taking social reasons for things having happened is something that could be taken into consideration, especially if in addition to that, we talk about therapy that someone's had or other things that they've done to deal with what's happened to them in growing up, for instance. So I'm in favor of leaving it in.
Someone want to bring a motion to recommend that we social factors of the applicant be added and kept back in as one of the aggravating, mitigating factors, I guess? Does someone bring that motion?
Yeah, I'll make that motion.
Okay, Larry brought that motion.
So,
You want a
what's the
second?
wording? Social factors.
Of the applicant.
It's here.
Oh, it's in red, okay. Yeah.
Does anyone want to second that
But
motion?
also, it shouldn't be
I'm sorry.
defendant, it should be applicant, right?
Yeah, because they've been changing that things.
I'll second it.
So we have a motion and a second. Does there want to be any further discussion on this?
You know, if anything, you know, it's very vague, you know, it's true, but at least it tells the folks at the bar that you gotta think about these things.
It's important. We think it's important.
Yeah.
The only comment I'd like to make is, I think I understand why those factors were excluded. The only problem I can see with that is it may give some applicants a sense of false hope because it's really contrary to the case law that is part of the moral character process. I guess the Supreme Court will, according to the case law, at least in my opinion, does look at the entirety of the applicant's life. It is examined, but if an applicant believes, well, they're going to take my background into account for the any bad moral character or evidence of bad moral character, it may give a false sense of hope to the applicant. That would be my only concern, because in any time, usually the bar puts anything in writing and it's on a web page or it can be traced back to the bar. In my experience, that has always come back to haunt us, and it's been, even if they said they heard something at a seminar that was presented by the state bar. So that would be just one of the concerns.
I mean, there's no question that the whole life of the applicant is considered in the context of rehabilitation where the person was, where they are now. But that's not the same as saying if you have a certain criminal conviction and have these social issues, the criminal conviction carries less weight in terms of the moral character analysis. That said, I think there's a motion on that.
Absolutely, and I completely agree with that. I mean, we're just trying to highlight an issue, something that needs to be considered. I don't think the entire life is going to be looked at. It's already being looked at. We're just making it clear, and again, in the effort of transparency, to let people know that this will be considered. But it's not going to erase a conduct. If somebody, committed a sexual assault, and the excuse is, or the reason is because of their childhood, if there's no rehabilitative action that's taken because of what happened to them in their childhood, it's not going to wipe out the sexual assault. Nobody's saying that, but there are circumstances in times when you look at the entire social background that maybe the outcome should be different based on again, making efforts to change your life, being involved in a gang, or being involved in a very violent, domestic violent relationship, but you were able to get past that and be rehabilitated. Those are very different things than saying we're going to give somebody a pass.
Okay, we have a motion and a second. Any further discussion? Okay, call for a vote. All in favor?
Aye.
Any opposed? Okay, going back to where we were, I believe, a little earlier, and that was the question about the column of aggravating and mitigating factors, whether that should be a single cell rather than multiple cells. I don't think we made any vote on that yet, or there's a motion on that yet. So is there anyone who wants to discuss further whether aggravating and mitigating factors should be a single cell, or multiple cells, or make a motion in that area?
I move to make the aggravating mitigating cell a single cell for all violation considerations that would incorporate an exhaustive list of all of the types of conduct discussed in the individual cells throughout the 22-page document created by staff's feedback.
Okay, we have a motion. Does anyone want to second that motion?
I second it.
Okay, we have a motion and a second. Do you want to discuss that further?
I'd like to touch on sort of Larry's point from earlier, which is just from a very practical perspective. If there are many, many rows and you have to scroll through the many, many rows, you may not see those aggravating factors, depending on where they fall within that cell, right? So I actually, for that reason, would recommend that they be segmented out perhaps in their own cell at the top or rather than at the bottom. But I'm trying to envision it from a perspective of an applicant looking at it. And if you're scrolling through and depending on where you are in the matrix, not seeing that language, it could be something that an applicant misses entirely.
I don't think I'm not quite tech savvy enough to say if this is possible on a website, but I'm thinking of Excel, they can lock rows. So if that is possible on the website, that's something, but I don't know, because I'm not sure on the backside of that, but.
And also, you know, I'm sure it's possible to have a link, maybe, you know, something, an asterisk in that right-hand column, wherever those factors don't show up, that, yeah, takes you to the top or takes you to a separate list or something like that. A lot of this goes back to Larry's point about design, which I wholeheartedly agree with. I'm sure everybody does. It's gotta be user-friendly.
And we can pursue, I'm looking for like a graphic specialist for this project before we post it, just to make sure it's user friendly.
Oh, that's a great idea. Bring in somebody from the outside, you mean? Yeah.
Good discussion. Any other discussion you want to put in this motion? I'll call for the vote. All in favor?
Aye.
Any opposed? Okay. So I believe that deals with page 1. Page 2 really just is aggravating factors. So looking at page,
Could we go back to page 1?
I'm sorry,
I'm
yes.
sorry. So I think it was then if we wanted to, so we already talked about the examples itself, but which wording we wanted to incorporate into the additional inquiries, although necessary or maybe necessary boxes. So the highlighted verbiage, I believe, is what Debbie and Judge Torrialba had given us, and then the blue on the staff feedback is what they needed. So we just need to parse out which one, I think.
sorry you lost me.
So now if you look at the copy with the highlighted, with Judge Torrialba and Debbie's suggestions, their suggestions are the highlights.
Yeah, this is the 8-page document with the yellow highlights.
Exactly. So those yellow highlights are suggestions having looked at the staff changes that are reflected in the track changes. So those either need to be one of them or the other, or somehow, you know, incorporated into one another. Or have them both, depending, I don't know if you all want to speak to, you know, sort of.
That we were going back to
I don't think that we necessarily, when the judge and I went through this and put in the yellow highlights, we were not thinking that it would necessarily say refer to adult misdemeanor, but in our heads we were, I think, thinking like if something becomes a misdemeanor, then it would be relevant under the misdemeanor column. But then other than that, like really we just fundamentally we just did not feel like municipal violations are relevant to the inquiry. And so that's, I think That's basically your question, right, David? Like, if the group wants to make a decision about, are they seldom relevant or are they not? And if they're not, then the kind of language you put in is probably what would work. Unless I am understanding.
Yeah,
That's exactly what it is.
So, I don't know that and Judge, I don't know if your position has changed, but I still find it hard to believe that a municipal violation is relevant to a moral character inquiry, but.
But then part of what we're telling the applicant is if all you've got is a municipal violation, we're not gonna really consider it a big deal.
Where does that come up? How are we saying that? We say that if we say it's seldom relevant.
On top it says seldom necessary, so they're gonna,
Well, I think it would, instead of it being the yellow highlighted, it would say, if no aggravating factors exist, an
But-
additional inquiry is seldom necessary.
but the head of the, oh, I see, yeah. Referring back to the head of the column, yeah.
well, okay.
Again, like what's an aggravating factor with a municipal violation? It just doesn't give them anything concrete.
So do you want to propose some language to add in those columns where it says seldom relevant, or just keep seldom relevant?
I think we just keep seldom relevant.
Okay. So do you want to, is there someone who wants to make a motion with respect to municipal code violations and vehicle code violations? We continue to add the term seldom relevant in the 6 boxes. Someone want to bring that motion?
If we have to go through each box like this, we're gonna be here all day. I think that the things that, and I'm not trying to be disrespectful, but I think that some of the things that staff says, if occurred in or after law school and pattern of violation, I mean, that is fine. I don't have an objection to that. Otherwise, it's seldom relevant, and you need to refer to it rises to the level of a misdemeanor, which is why it came to refer to an adult misdemeanor. Most of these things that are going to have aggravated factors as a municipal violation would also be a misdemeanor, which takes it out of this column and puts it into a different column, which is why I think we have put seldom relevant refer to adult misdemeanor, because if and the only example that, as Mr. Glass had said, failure to obtain a license or business permit, that could be something that we would be concerned about, but even as if it's an infraction, I don't think so, but if it's a misdemeanor, yes. That means that you're gonna start selling marijuana, you need to get the requisite licenses, and if you don't, it's a misdemeanor. But some things, if you're just a street vendor and you forget to go get your little license for your cart, I don't think that's a crime of moral turpitude that we're gonna be concerned about. I hope not, because that's a person just trying to make a living and didn't go get the business permit needed to have your ice cream, fruit, and churros on the street.
It used to be.
Right, I mean, or if you're selling out of a shopping cart, now you can't do that either. I mean, there's all kinds of things that requires you to get a business license or permit, and I don't know that rises to the level of not being a good candidate to be an attorney.
And that's why, I think that's what staff was getting at by suggesting if no aggravating factors exist, that would mean seldom relevant, essentially, or put in the language of the title of the column, additional inquiry seldom necessary.
Right.
And it is hard to imagine aggravating factors that could kick that stuff up to additional inquiry necessary that wouldn't put it in a different category, so it makes the question moot, whether in this category. But all sorts of factual circumstances come up. Maybe somebody has 20 violations for not doing that, getting the license, and it shows sort of a repeated disrespect for the law after having found out about the requirement. I'm thinking out loud, but there are all sorts of interesting factual circumstances that arise. It's at least hypothetically possible, I would think, that something could aggravate a municipal violation.
So David, in that case, are you saying that the definition of aggravating factors would be what's included on the third column, i.e. patterns? And again, I would ask that if you're talking about 20, I think we should be clear that we're talking closer to 20 than we're talking about 2 or 3, right?
Yeah, pattern is vague.
Pattern is vague. I'm apologizing that I'm gonna be pushing you today, but as we're getting closer to what's gonna be final, and I'm imagining all these applicants and the number of applicants who aren't even applying because they're deterred by what the language is on the website, right? So pattern, they look at, I have 2 or 3, I can't apply, right? And these things are racialized also. If you're, urinating at a football game, you're probably not getting a municipal violation, but if you're doing it in a particular neighborhood, you might get indecent exposure, right? So, but just to be clear, what you're talking about, aggravating factors in the column is really, in your mind, patterns, excessive patterns, or an excessive number, or if it happened in law school or after. Is that what aggravating factors are for purposes of this?
Well, so the vehicle, yeah.
I'm just on municipal violations still.
Yeah, you could say those are aggravating factors. Those are, factual circumstances that could make an additional inquiry necessary.
In commentary, we probably can provide some guidance, even though we're never gonna have a concrete formula where you just plug in the violation and everybody knows they're gonna be treated the same. But I think with some explanation, one can say, the number of violations becomes increasingly important with how grave the offense was. And I think we'll tend to understand with some degree of agreement that, for example, unlicensed cart, 20 violations may be quite serious, but not much less than that. Where if it's a graver offense, 2 or 3 violations might be considered to have the same kind of factor. In the same way that the amount of time that's passed between the violation and the time of the application, there's more leniency towards very old violations than ones that happened while in law school. And we'll never come up with a formula that's just plug in and we've got the result. But I think it's helpful for everybody to know if your violations are rather recent, the risk of not getting admitted or readmitted is going to be a lot higher than if the offense was 15 years old. We'll never be able to offer anything with more clarity than that. But I think the same place with others. The commentary will help staff sort through how to address these without giving anything more concrete than that. But at least that's a good step forward from what we have now.
Yeah, absolutely, and that will come into any sort of discussion about rehabilitation. And some of these issues will be addressed in the statement and guidelines or whatever it ends up being called. But the time, and in fact that should, I imagine that is in the mitigating factors. Yeah, time since offense is in there.
So pulling this back in, this is the working group's recommendation to staff. So we listen to staff and respect what staff has to say, but if we say we want something in the matrix, we can have a vote on it and say, this is what we as a working group feel. So if someone wants to make the recommendation that we add the yellow language that we've got from the judge and Debbie.
The system has detected that a minimum number of lines are connected to this conference. Do you want to continue your meeting? Press 1 to confirm. If there is no response,
So if someone wants to bring a motion, we can bring a motion on that issue. If someone wants to move on to something else, that's fine.
I've got a question.
Yeah.
We're going to soon be receiving a version with the staff recommendations, but non-redlined, and it'll be basically a new draft that we can then consider and propose changes to, is that it?
No, so what we're based on, Jim we had a discussion with Jim, and he had asked that staff look at it, and offer their feedback, which is the track changes, so that way you could see what was there and what was not there. We didn't accept them, so that way you had it all in one. It's just for your consideration, again, as Jim mentioned, this is the working group's final work product. These were just the suggestions by staff, so we need to finalize what is going into each of these boxes today. So it may be that we disregard what staff said and we keep seldom relevant, or it's a combination of the two, something of that nature. But so there's not going to be another staff document. It's just what's here, and then we'll finalize it. And then all we're going to be doing on the back end is just trying to make sure it's style compliant and as easy to use as possible. So.
But it is the case that there will be another document with whatever the working group decides
That's what I
today.
wanted to confirm, because we can make suggestions after we receive that, correct?
Probably not, no. It's gonna go to the Supreme Court after what we do today.
Well,
For the comments, isn't it?
there is one more meeting.
There's one more meeting, so ideally what we were hoping to do is, because we still have the statement and guidelines to finalize as well, is finalize all of the language for the matrix, and then we would just bring back the one that has been formatted for I guess final review, and then the statement and guidelines, hopefully we'll go through it today, and then any changes we would then accept and finalize at the next meeting, because at the next meeting we have to have everything finalized, so that way we can give it to the Supreme Court and to the Committee of Bar Examiners, so they can review it prior to their meeting.
So that's what I wanted to clarify is the process. So first go to the Committee of Bar Examiners, eventually the board, and then to the Supreme Court.
Oh, okay. Different order.
I think at some point Donna had asked that we solicit the Supreme Court's feedback prior to the committee making their decision, but I guess we could talk about that afterwards.
Okay.
So.
But except for some minor editing where we say you didn't get what we voted on, what we do today is going to be the final draft. That's the idea.
All right.
So,
For the Team 3 matrix, we had a change that we suggested after we received the staff input. And I'm wondering if we ought to talk about that today. It was a change to a definition on moral turpitude. So if there's no additional chance for us to make that change, then we should talk about it and vote on it today, I'm thinking.
And we do have that, so on the feedback from Judge Torrealba and Debbie, so the last page, just for ease of use, we had put in what your old definition was and what the suggested new definition was, so we definitely want to get to that today, so.
okay.
All right, so I will make a motion to, for the first page and under, I guess, additional inquiry unnecessary, and on the working group, it's additional inquiry seldom necessary. In that box, boxes for the municipal code violation and the vehicle code infractions, the language would read seldom relevant if no aggravating factors, semicolon, refer to adult misdemeanor.
Okay, so that's a motion before the working group. Does someone want to second that motion?
I'll second it.
Debbie seconds it. Do you want to discuss it further? All in favor? Any opposed? Okay. Debbie, you mentioned that you didn't like the word patterns. You thought it was vague under aggravating factors. Do you want to discuss that further, or should we move on? Sorry to put you on the spot.
Well, we did, there's also the possibility of, since, I think somewhere pattern is also in the aggravated and mitigating factors, so it could be if occurred in or after law school and aggravating factors exist, rather than just specifying pattern, something like that. That's fine.
I noticed, Debbie, you and the judge also on page 2 said define patterns.
Did so, I like that, Myron was saying, come up with a grid. So in the law, if it's 5 years or within 5 years, typically that is the time frame when things become, when things are most relevant. I don't know if we want to throw out a number like that or not to give guidelines for that, but in terms of patterns, typically it's got to be, again, in the law, it's got to be 3 or more. So we could define patterns as 3 or more, and obviously that leaves lots of room for interpretation. But I think it gives somebody some guidelines that if you have 3 of one thing, you better be thinking about it. And then, of course, you need to look at the timing of it in law school, after law school, how old you were, and all of those other things. But that's all covered under the aggravating and mitigating factors. So I don't know if we want to define that within the aggravating and mitigating factors, say patterns are things that, you know, yeah, something that's conduct that's consists of 3 or more.
So suppose we could have a couple different type of motions. We motion to say that's to be added to the matrix is defining patterns 3 or more, or that we can tell staff we want somewhere in the language, somewhere in the document, generally the patterns to be defined as 3 or more. Does anyone want to bring a motion one way or the other? Third way?
Can I ask the staff, when you think about patterns, like what do you have, you know, when you think about whether or not a pattern is relevant, typically, like, what are you looking for?
I think it was Dean Steeds who said it earlier. I think it depends on the type of offense. So, for example, like we might see 5 speeding violations, but if it's over a spread out period of time, you know, it just seems the more, I guess, one-off circumstances maybe versus like if there's 3 DUIs, I guess the severity of the offense itself, I think, is something that we consider in the pattern.
Are you willing to define that in something?
I don't know that you can, that's the problem.
Well, but even just giving this information, right, depends on the period of time, it depends on the severity of the offense, like.
But we have that in the aggravating factors. I mean,
Yeah, that
we
should
have
be
all of that.
reflected.
I think that's all in there, it's just not, I don't think we can come up with a if this then that. I just, there's too many
The
possibilities.
cost we pay by just saying there's considerations of the spread of time and the frequency of violations is that we know that there will be similarly situated people that are going to get a slightly different response. But the trade-off from that is having a formula that's so rigid that individual considerations are taken off the table and staff is stuck saying, we're responding this way and it just doesn't feel right. We're so constrained by this that we have no choice. I think the balance of that, the best we can hope for is some degree of free play by saying length of time, frequency, and severity, all of factors taken into consideration and finding an appropriate response. That still leaves a lot of ambiguity, but it's vastly better than what we have, and I don't know that we can get much better than that.
And I like that language, we can put that even at the very beginning, you know, the length of time, severity.
So length of time, severity,
And frequency.
One more time?
Length of time, severity, and frequency.
Thank you.
And I agree with that. I don't think it's possible to equitably select a number, 3 or 5 or more, because it's so dependent on the nature of the conduct. So I would not be in favor of including a specific numerical definition of a pattern.
Okay, does anyone bring a motion at this point? Should we move forward a little bit? Okay, having heard the motion, I will next mention the fact that I believe lunch is ready. Do we want to eat lunch now, short lunch, or do we want to go a little longer?
Longer.
Was there a
Bring it
paragraph
in here
motion?
I don't think you actually brought a motion on the
Oh, I thought
definition of.
you brought a motion on the second and third columns for muni and vehicle code violations.
Yeah.
Was that voted on?
That one was not voted on yet.
Oh, I'm sorry.
No, I thought we voted on that. If no aggravating factors exist, refer to adult.
Oh,
Did we not vote
First
on
and a
that?
second, but no vote.
Oh, okay.
I thought we did vote in, okay, so can we have that motion again?
So it was for the municipal violations of vehicle code infractions, so seldom relevant if no aggravating factors exist, refer to adult misdemeanors. Then the second boxes were going to be changed to say, rather than pattern of violations, if aggravating factors exist. So for, again, both of those. And so the motion was by Judge Friabla and the second was by Debbie, so we just needed the vote.
Okay, so, again, all in favor?
Aye.
Any opposed? Sorry about that. Okay, so, again, do we want to stop for a short lunch? Do we want to keep going?
Can we just bring the food in here and keep going?
That's fine with me.
So it's a working lunch.
So it's working lunch. Yeah, because we're moving slow and we want to
Yeah.
get out of here today.
Yeah.
We have a long way to go.
Right.
Okay. So back in 10 minutes or less.
I think so, yeah.
Okay, folks, we're back live. During the break, we talked to council, and it was suggested that to speed things up a little bit, rather than making individual motions on each particular section, we try to go through multiple sections at once, and then maybe do one motion at the end, accepting all of our recommendations that were in discussion here. The risk in doing that is that if someone doesn't like one of 12 things we've done, then that can delay things. So if in fact there's something you don't like the way the discussion's going and you feel like we should vote on a particular item, please say so, we can vote on that particular item. Otherwise, I'm going to try to lump things together and move things on a little faster. So I believe we're now at juvenile misdemeanors. We have what our original comments were. Staff moved the examples, I believe, over to the other columns and reduced the number of the examples. This is juvenile misdemeanors and juvenile felonies. Let's just deal with them together. Does anyone have any comments about whether they like what staff did or didn't like what staff did, or have questions about what staff did? Again, this is juvenile misdemeanors and juvenile felonies.
For consistency purposes, with the municipal code violations and the vehicle code infractions, do we want to use the same language in these seldom necessary box, so seldom relevant if no aggravating factors exist?
That makes sense, yes.
Is that for both felonies and misdemeanors? As long as it's juvenile.
Yes.
Okay. Anyone else have any comments or thoughts with respect to juvenile misdemeanors and juvenile felonies? Okay, then moving on to adult misdemeanors, we have a couple of comments. Maybe staff can explain what the stuff in pink is on the staff recommendation, and then maybe Debbie or Fred can explain what the yellow highlighted items are on their matrix under informal conference may be necessary.
Mm-hmm.
You want staff, you want to start what the pink is? I'm sure
I
why.
don't remember, but
I think it was just, in the application itself, it cites specific statutes which don't require disclosure. So we're just trying to refer them to the instructions itself.
Yeah, and we found that people use the word expunge to mean sort of different things. So we just wanted to make sure they understood exactly what it means here.
I actually agree with that clarification. Makes sense.
Okay. And do either of you want to talk about the yellow section, including impeachment list of crimes and allude to list or allude to list?
We were trying to just get a little bit more concrete about crimes involving moral turpitude can be vague depending on what context you're speaking about them. So, in an immigration context, it can be a broader set of crimes than for impeachment. And so we're hoping to get a little bit more concrete about when you say crimes involving moral turpitude, what do you mean? And the judge suggested that we perhaps use the impeachment list.
I don't know, I brought it, I don't know if that's what you wanna use, I have a list of crimes that, are admissible for purposes of impeachment. That was the definition I was falling upon. I don't know if it's the same as for purposes of immigration, but I don't wanna go through all of it. This one is 6 pages long. I can send a copy. I don't have it, I just kind of grabbed what I had in my office and brought it with me today.
And that list is from what source?
Case law.
Okay, that's fine.
So, yeah, cases, the evidence code, and case law that describes and defines what a crime of moral turpitude is. It's the typical things, assault with a deadly weapon, auto theft, battery, things of that nature. What might be interesting is some of the things that are not considered moral turpitude. So I guess that's something, simple battery is not, but assault is. So I guess that's something to determine.
Yeah, and I know the Supreme Court has said in moral character, in at least one case, the definition of moral turpitude varies depending on the context, the legal context. I mean, making it even more helpful. It's always a slippery definition.
At the very least, we could include reference to that, for example, C, impeachment list, something of that nature.
Right, and again, say included but not limited to language, and I'm happy to provide, I'll scan and send this to you. I don't even remember where I got this from. It's from, this one particular one's from the Santa Clara County District Attorney's Office, so it's things that I picked up over the years and kept.
So you're
I don't
talking
have
about,
it in a PDF form, otherwise sorry.
talking about impeachment of a witness for purpose of credibility?
Yes.
Okay. Sure, I understood the right impeachment.
Yes, absolutely, and it has to be limited to crime of moral turpitude, so that's the definition that I fell on.
The only question there is also do we care, I guess this comes up in aggravating factors, so never mind. If it's 25 years old, is that gonna require a conference?
Right now, I think it's covered by aggravating factors. If it's too old, it's not gonna be, it's the same thing, it's not gonna be relevant, which is exactly how it applies in the law.
Yeah, but I guess I'm just imagining the applicant. Is the applicant gonna know that? How is that signaled to the applicant that 25 years is probably and maybe that's in the commentary that Myron's speaking about, that needs to come with it.
So as to moral turpitude, may I just say that I did look for cases where there was something provided in the way of wording to tell those who are trying to find out what it is, what the guidelines are. I couldn't find much. There are a number of California cases, most of them old. I did find a recent federal case, Garcia Martinez versus Barr, a 2019 case, 921 Fed 3rd 674. And what they've done, what I should say is what happened in that case, as well as what happened in the older cases, is they used the definition from Black's Law Dictionary. And I proposed to our team for our matrix using that definition from Black's Law Dictionary to replace the wording that we had suggested previously. But I'm thinking that that definition, the one from Black's Law Dictionary, should be enough. It certainly doesn't provide a lot in the way of guidance, but it provides something.
Can you repeat it again?
What's
I can read it to you
Yeah,
now.
sorry.
So let me just say that previously we had in our matrix this definition: an offense involving moral turpitude is one that involves either dishonesty, like fraud, or base, vile, or depraved conduct that is shocking to a reasonable person. what I'm proposing, what our team is proposing is a replacement of that with this, which is from the Barr case, or the Martinez case. It's from Blacks. It's as follows, quote, moral turpitude has been defined as conduct that is contrary to justice, honesty, or morality. And then we're proposing that in parentheses we put Black's Law Dictionary. I suppose we could include the definition and then provide some examples. I don't know that that is a good way to go. Maybe we should.
The most recent definition by the California Supreme Court is the case In re Lazansky, and it's somewhat similar to what you just read, but it includes any conduct that is contrary to current social mores, dishonesty, or something that's repugnant to societal norms. Now, that's a broad definition also, but for disciplinary purposes, that's our most recent Supreme Court definition.
It seems like we're moving to a definition like Blacks and what the courts are using. You can't give it any more authoritative than that. But
Except for the California Supreme Court's the one that's gonna be doing the evaluation, and we should probably use their definition.
The frustration is that it can go counter to our purpose of trying to bring more clarity when those terms are more expansive. Like the old definition, when it has dishonesty like fraud, delivers a lot narrower content than just the word dishonesty.
Which is why I propose having the list of what the courts have held is defined, what constitutes moral turpitude.
And we have specific examples from
And we
moral
have
character
specific
cases.
examples. We have tons of examples, and you can just put them, people just have to look at the list.
I think that's hugely helpful. If we go with the more current definition, I think it begs for having that kind of illustration from case law and what moral turpitude has been defined through various cases.
How old is the Black's Law? How old is that?
That's correct. That's the
No, but I
correct.
mean, when was that written?
Just after the Magna Carta.
Okay, so I gotta tell you something, I like that one better, because you wanna know why? Because start talking about social mores, violate social mores, shocks the average person, like, I'm sorry, okay, but that was the way they used the law to discriminate against minorities, okay, in the good old days, okay? The hell with social mores, it really is about those three things that are in the Black's definition, that's what it's about.
Well, that's an argument you have to make to the California Supreme Court because we're bound by their decisions.
Well, maybe they're wrong. Who the hell are they? I mean, seriously.
Well, the CBE is an arm of the Supreme Court, and the Supreme Court has the authority to accept or reject any of this.
And just so you all understand the way that state and federal law works, California Supreme Court is precedent, and federal law is, they can look at that, but they're not bound by it. So the definition that they're going to follow is going to be the definition that they have articulated, so.
I found older California cases with a definition, it's almost exactly like Black's, but not quite. And it reads, conduct involving moral turpitude has been defined as everything done contrary to justice, honesty, modesty, or good morals. So very close to the Black's definition. I looked for a recent case. I'm not saying that there isn't a recent case, I just couldn't find one. I found the older California cases, some of which involve bar matters and moral character determinations. It seems to me that a definition, either Black's or this one that I found in older California cases would work. Could use them along with the list that the judge is suggesting. Maybe that would be the perfect way to go.
Last thing I'll say on this point is Michael brought up the most recent definition in the context of a disciplinary case. And the court has a bunch of law indicating that it often looks to its disciplinary cases for legal precedent in the context of moral character determinations. So that may be if that's the most current definition and it's in a disciplinary context, that is probably the controlling law.
Yeah, on the other hand, we as a working group can say, we think it should be this, and the Supreme Court can say no to us, but we can say, this is what our opinion is, how it should be interpreted with a person's moral character. They don't have to accept our views, but we can say, we have a different opinion than you do, or slightly different opinion. So what do you want to do with this? This is my next question. Do you want to go with Michael's definition? Do you want to Michael's definition with the judge's list, or how do we?
May I ask if Michael Glass would read his, again, the one that he found, one more time, please?
Oh, I just recited
Oh,
all
was it?
from
Okay.
memory off the top of my head. I don't have the exact quote, but the case is in Ray Lazansky.
Is that LIS?
LES.
LES.
And how close does it track to the one that I read from the older?
It's somewhat similar. It incorporates elements of
All right.
what you stated.
Well, I would agree that, personally, I would agree that we ought to go with whatever's the most recent.
Okay, anybody have any thoughts other than add that definition into the decision matrix?
I think that's a good idea with some example or what has been determined to be, moral violations of moral turpitude. I think that would be very helpful.
Does that
Again, including but not limited to.
Does that work for you? Okay. I'm going to move on, but stop me whenever you want to discuss something. I think we've got felony convictions next. I don't know that we have any comments from anybody on.
I think we have alcohol and drug-related misdemeanors.
Oh, I'm sorry. Thank you. You're correct. Alcohol and drug-related misdemeanors. Again, I don't see, staff made some recommendations. Anybody have any comments about staff's recommendations?
And we just recommended changing it from DUI reckless driving conviction to the more broad alcohol or drug related to kind of be consistent with the rest of the matrix. And again, we pulled these from our current level items that we use, but that was the suggested change.
I did have a question about the first box under additional inquiry seldom necessary. Under the first bullet point, it was added properly disclosed. Does that mean properly disclosed to the law school? Or to whom?
I think the intention there was to us on the moral character application. I mean, the idea is also captured in the general definition of moral characters, including candor. And then there's even a separate section in the matrices that addresses omissions that would also capture that idea. But I think that was to emphasize that it's seldom necessary, but we're assuming that you disclose and we're candid.
And you could also add, C, omissions, misrepresentations,
Yeah,
on
I
that
think
one.
that just feels a little out of place because wouldn't that be true for any of the
Yeah,
boxes?
yeah.
So you're suggesting this properly disclosed be broader than just this one particular cell?
Or maybe just delete it since
Since it already is.
it's already in
Yeah.
a different section under omissions.
Okay, that applies to all cells, not just this cell? Okay. Anybody have any issues with that? Then.
What do you do about things that have become like legal, but that someone was, I guess if they were convicted of it when it was illegal, I'm thinking about marijuana,
Right.
so
Well,
I guess in violation of the social norms.
It definitely impacts the moral turpitude analysis. So something may no longer be moral turpitude that used to be considered moral turpitude, which would in turn affect the rehabilitation analysis because you wouldn't have to have the long period with exemplary conduct, that definition, when you have moral turpitude.
Homosexuality.
Is it worth
I mean,
like
it
some
would
kind
still,
of
I
commentary on
suppose-
that? Like, I don't know,
Maybe.
just.
I mean, I was gonna say, it would still evidence disrespect for the law, but, I think the fact that it's become legal matters, and I don't know how you might wanna.
So maybe like just a footnote on that or something would be, for a commentary would be helpful. I suspect that some of your applicants, that's all they have is maybe a single marijuana possession when they were in college.
Okay, moving on then to felony convictions. Again, it looks like staff moved the examples out of Purcell, and I don't think we have examples at all now, all examples are out. Anybody have a comment with respect to staff's recommendations on felony convictions?
No, we just added, again, as we did with the misdemeanors, to like be more concrete about what your list is of what is a conviction involving moral turpitude. So it would mirror what you've done for misdemeanors.
Okay. Moving then on, conviction of drug sales and possession of narcotic substances. I believe Debbie and the judge had put in there no aggravating factors, it's just defined. Comments on what you want to do with taking that out or expanding on it, or something in between?
They added that.
We added if no aggravating factors exist defined.
I think you just highlighted, you said
Yeah.
defined.
We added it.
I think this is similar now to the language that we're using in the earlier ones, and since we're defining the aggravating by the list we have on the right-hand column, maybe that concern is no longer there, I'm not sure.
Yeah, I think we're fine with it now. It just, I think it was the same issue throughout that we were flagging. So it's already been addressed.
So moving on to job termination, other than changing the column headings, I don't see there's any change there. And the aggravation and the mitigation is gonna come out, or what are we gonna do with those? It's on page 7.
Oh, on page 7?
So I believe the
Now we're on page 7 of the
staff feedback.
staff feedback.
So I believe
So are we only looking at one list now? We don't have to look at two?
yes,
Okay.
because you guys were the only ones that we received that from.
Oh, okay, great.
So I believe that the agreement earlier was to make one list of aggregating, mitigating factors for everything, but, so that would be to all of them. The other option, I guess, if we wanted to revisit that, is having one list per, let's say like value, like the very top right hand, so you could have one list for honesty, candor, trustworthiness, fairness, one list for respect for and obedience to the law, or do we just want one exhaustive list overall? I think a lot of them are repetitive, but some of them do get a little bit,
Yeah, I like actually what you just described.
the breaking it out.
Yeah.
So with respect to the areas of criminal law violation we discussed earlier, we might have one set of aggravating mitigating factors. With respect to job termination or honor code, we might have a different list.
Some of them might be overlapping, but they're more, it allows you to be more specific in those areas.
Okay.
So you don't have to talk about expunged offenses when you're talking about job termination. It doesn't even make sense, right?
Right.
But it makes sense for all of the things related to the violations of the law.
Okay, so but on job termination, does anyone have comments on the aggravating, mitigating factors or any other things this in our 5 cells? I'm going to keep moving forward unless I hear something. So honor code violations, undergraduate, postgraduate. Does anyone have any comments with respect to what's in those 5 cells? Moving on, honor code violations, law schools. Does anyone have comments with respect to what's in those 5 cells?
I just have a question for the group for this one and actually the last one. So at some point, it was added, the examples to be added. And so we did survey some of the schools and we provided that information. But I think it still wasn't a lot of consistency, so do we wanna just take that out, the examples to be added, and just leave it as defined by the school, or, what do we wanna do there?
This is the middle cell where it says examples to be added on page 7.
So I think where this gets challenging is that, schools will have a varying degrees of incidence, but they may not define them in this way. So infraction, versus serious violation, at what point is that determination being made and provided to the staff? You know, like at my school, it's easy because we have infractions and serious violations. So I could easily say this student was found responsible for an infraction of the code.
So maybe, I'm trying to think about this, rather than adding specific examples, since they wouldn't apply across the board, we could say infraction or minor violation.
Yeah.
And if you wanted to go further, you could say that resulted in a warning or or verbal reprimand, like something of that nature, so you know it's not a suspension, but maybe that's too far. I mean, those are.
I mean, it's
School
certainly
action.
possible, I think.
That resulted in school action? I mean, it doesn't have, is that what you're trying to keep it broad so that it's can incorporate many different things?
Well, under the current language of the application itself, I believe it requires disclosure even of warnings.
Right.
Right? And you could get a warning for a very low level. So I think we just need to somehow properly articulate that we're talking about minor versus serious.
So maybe just infraction / minor violations.
Or, you know, minor violation, serious violation.
So we want to put the word warning in there, so that if you just got a warning from the school, they know it's, they're going to ask about it, but it's probably not going to be a deadly offense or not. Hearing nothing, we'll leave that out for now. Okay, moving on to honor code violations, law school. You kind of covered that a little bit. So then we've got omissions and mischaracterization on applications, licensing agencies, law schools, etc. Maybe person, this is on page 8. Any comments with respect to that, those 5 columns? Self? Okay, going on to fraud. On page 9, we've got some highlighted pink. Any
So
comments
is
on
the pink, is that staff or what is pink?
That was staff, I'm trying to see, I think what happened is that there's a footnote here, maybe that on the printed copy didn't print, so I'm trying to look for the actual page. I don't know if you recall for the off the top of your head. I think you're gonna have notes, that's why. Okay, so the note on that, I think when we were discussing this as a group, it was the consensus that that may not make sense to an applicant, and that wouldn't provide enough guidance, so maybe clarifying it somehow, or removing the scaling but providing a different definition. We didn't have a suggestion to it, it was just, that's all the note says.
So I think I would recommend that we sort of revert to what we decided earlier, where whatever we decide on for the additional inquiry may be necessary. Then for informal conference, we can say informal conference as needed based upon results of additional inquiry. But then we still need to figure out the additional inquiry parameters.
The language was as needed as a result of further investigations and totality of circumstances.
Or as needed based on outcome of additional inquiry and totality of circumstances. Well, I think we decided additional inquiry is always necessary, right?
For fraud.
For fraud, yes. So additional inquiry may be necessary. The
Always.
Allegations of fraud exist or something, maybe.
Yeah.
So I think you're trying to get at, major versus minor. So, breach of trust, number of victims, amount of loss, those kinds of things. So scalability is definitely a vague term. So maybe just put, they have financial number of victims, things of that. Maybe we include there some examples. Breach of trust, number of victims, amount of financial loss, included but not limited to, kind of language again.
But it's hard to think of a situation where you've got a fraud where you would say it's really minimal. Just the very nature of the offense of fraud really questions whether one should be practicing law. Whether it's stealing, signing your mom's check, and going to the bank and getting $10, or stealing mom's credit card or whatever, you still violated someone else's trust, and that really requires a serious consideration before you give somebody a license that's done that.
So maybe that you just have the allegation then under the third column, the additional inquiry may be necessary, so there's no finding by anyone, it's just the allegation exists, and then, so like in those instances, typically if someone says that there was a civil case and there was an allegation of fraud against them, we do ask for like the complaint and their answer and those things. So I think that's where my head is going with that.
Further comments?
I think that makes sense.
Admission, denial, practice of law. And I guess you're saying it depends on why the denial existed, whether it's because of failure to pay dues versus some sort of moral character considerations.
That's correct. That was our thinking.
And then we have admission, license denial, and non-legal professions, a notary license, real estate license, maybe liquor license, I'm not sure that would apply. Any comments on those cells on admissions, non-legal profession?
For both of them, I think I would also err on the side of, in the informal conference column, using the same language that as needed based on outcome for consistency.
Also, in this one, I see the boxes next to admission, denial, practice of law, admission, license, other, or non-legal profession. The boxes are empty, so would we just get the first one for under additional inquiries, seldom necessary? Would we just put NA in there? Just jump right into it, so just include an NA in there.
I think so just like how the fraud one has.
Just don't want to leave a box empty.
Moving on to page 10, bankruptcy. We've got discharge, no objections, objections dismissed, finding of fraud. Any comments with respect to bankruptcy cells? Bottom of page 10, past due debts, debts and collection. Staff added some language, it looks like, to informal conference necessary. Okay, moving on to unpaid state and federal, should we say income taxes rather than just taxes? I guess there are all kinds of different taxes we want. Sure.
Yeah.
So under mitigating factors, the failure to take steps to repay, I guess I would like maybe to say failure to take steps to address. Because there are times when you just can't pay, but at least you're addressing it. I think that would be a mitigating factor.
But really, aren't we eliminating, if we're doing one long list of aggravating and mitigating factors, I don't think that would likely be included.
But I think we've decided that with respect to some things, we're not gonna have a single column for everything. For school offenses, we're gonna have a separate maybe section, and for this, we may have a separate section. Just my thought, that we're talking about. Okay, any other comments on unpaid federal or state income taxes? Professional complaints attorney. Again, we have unsubstantiated, minor, major, and aggravated mitigating circumstances. Any comments in that area? Not sure we see a whole lot of those anyway.
When this column is merged into others, would it be clear that these are not an exclusive list? But there may be other mitigating factors as well.
We could put that, I could add language to the disclaimer.
Because the list we talked about earlier about the gravity and extent and time seems to apply to almost all of these, if not all of them. Because I was thinking in terms of the, there's reference to the age of at the time of the failure to pay. So also, there was a relatively minor tax fraud 20 years ago. That'd be more relevant than a current state of continuing fraud. But I hate to repeat the same thing in every box. When these are merged, if there can be some kind of standard that would apply to all of them as well as the individually listed ones.
I think this is only addressing actually currently due.
The system has detected that a minimum number of lines are connected to this conference. Do you want to continue your meeting?
I don't know that we have anything here that says about somebody who didn't pay their taxes years ago. It's satisfying to be if you currently owe taxes. At least that's how I saw this.
So do you want to add, instead of saying unpaid tax, you guys add the word current in there, or somehow indicate that it's still an outstanding issue?
There would seem to be an odd quirk to have currently due taxes. We look at mitigating factors to say.
So there's some people who just can't pay their taxes, and at least in the past, we've kind of said, you know, are you addressing them? Are you trying to set up a payment program? Are you talking to the government rather than saying, no, I'm sticking my head in the sand and I'm not talking to them at all? And I think that's what we're trying to say here is you have to communicate with these people and explain the situation. And if they say you can pay $50 a month, then maybe we accept that.
That seems like that should be accommodated because that makes a lot of sense. I'm not sure that that's clear here to the.
Yeah, maybe instead of current, outstanding, unpaid, past due, state or federal.
Outstanding?
Is that any more clear than current?
I'm fine with outstanding.
Yeah, no, outstanding's good. I guess.
Could add another bullet point for mitigating circumstance.
I was gonna say, because you brought up another point, so go ahead.
That's something as a mitigating factor is that there's a payment plan in place. That probably could be worded better, but that's the idea.
Payment arrangements, compliance with payment arrangements or something. Okay, so can staff maybe kind of think of some language we can put in there?
Yeah, the negative implication of the aggravating factor, essentially.
And then I guess you brought up a good, since it's, you're talking about current, do we care if they had unpaid taxes in the past and they're current now? I guess as long as it's not an issue of fraud, right? Fraud would fall into the other box and we would be fine as long as they're I guess, I don't know.
I mean, one could imagine, you know, if there was someone who didn't pay their taxes for 30 years And then they made good the day before the informal conference. I mean, I'm just, throwing it out there. You could imagine a circumstance under which they would be current, but it would still be relevant.
And while it's not a perfect fit, but we have that first column for additional inquiry is seldom necessary. I think somebody who had a tax problem years ago and does not have one for a sustained period of time, that's probably doesn't warrant further inquiry.
That's what I meant.
Yeah.
That's more what I meant. So I think it's probably not relevant. I didn't think, you're tricky over
We
there.
go to a few of these conferences.
Like, I just let you see it all.
Dean Steves, could you provide the language you just said again, Dean Steves? Could I ask you for the language again that you just said? About the, like satisfied,
Oh,
the way you said it.
that, if there was a, non-payment of taxes some time ago, I can't do this nearly as articulately.
Sorry, now you're on the spot, but
Some
yeah, okay.
time ago, but,
Has since been
the
remediated.
individual has been a sustained good taxpayer since then, that this, it may be an issue for which no, additional inquiry is necessary.
Yeah, it would almost be, per se rehabilitation, just on its face at some point.
You can't be, miss your taxes for 30 years by mistake or error.
Well, that's true. Good point.
So I think we dealt with professional complaint attorney, unless someone's got some further in that area. Moving on to page 12, breach of fiduciary duty. And again, I guess the difference is that a complaint being made by a civil lawsuit or a complaint with the state bar or another bar that's unsubstantiated versus one that's certainly pending or one that's pending and is aggrieved. Any comments on breach of fiduciary duty? Okay, moving on to page 13 that has all kinds of different stuff on it. Michael, this is ours. So it looks like many of this was just a change in wording.
That's right.
I think so, and then,
Yep.
it, like the big crossouts on the bottom, I think, you had said if it doesn't include any of these, but then they brought up again, they think that an applicant might read it or misread it and then think, oh, it doesn't need to be, like seldom inquiries unnecessary, and I don't know, they're just concerned about the applicants misreading it.
To mean what the disclosure obligation is. I mean, you can't guard against every mistake an applicant might make, but I think that was the thought, that some of the investigators were concerned that applicants might see this as an exhaustive list of things they need to disclose.
And then you've got the aggravating and mitigating factors, which again, I assume in this case we would leave, maybe make one cell for multiple civil actions. Again, this would be different than criminal and different from the school operations. So anybody have any comments on civil actions on page 13?
I do.
Okay.
I'd just like to say that the changes suggested, I think, are good ones. As to column 1, civil action, it seems like we have 3 categories of situations there. Family law cases is the first one. The last one is other civil cases, but there's one in the middle, and it seems to me that it needs a heading of some sort. I would suggest that we just take the heading that's at the bottom of other civil cases, maybe put it up right before where it says plaintiff in a case. So that we'd have family law cases and then the wording following it. Then we drop down to other civil cases, and then the beginning wording could be plaintiff in a case such as a contract case, landlord-tenant case, and so on. Maybe end with, under that category, end with less than 5 cases if no aggravating factors exist. But the overall point is, we have a heading for family law cases, a heading for other civil cases, but we need a heading for that that's in the middle, and I think you can just use other civil cases to cover that. The only other suggestion I have is stylistic, which is, well, it really is, it doesn't need to be stated, I guess, because we're gonna put aggravated mitigating factors into a separate document, but I was just going to say that this is a very small matter. The A next to the fourth bullet needs to be capitalized. For a cause of action, and so on. But everything else, it seemed to me, on that page looks good.
And that is something we talked about. You know, this thing's gonna be gone over with a fine tooth comb and made consistent in terms of bullet points when capitalization is used.
Right.
Yeah, your point is well taken. And you know, I don't know how fancy it's going to get in terms of design, but now I'm imagining, I mean, we all are feeling like we're locked into an 8.5 by 11 piece of paper. I mean, if it's on a computer screen, there might be different boxes. We'll see.
Okay, moving on to the bottom of page 14, administrative proceedings, adjudication, action. Which just like some removal of specific examples, even more of a no aggravating factors exist. Michael, any other thoughts on that one?
No, well, the thoughts, those changes are agreeable to me.
So bottom page 15, we've got code of conduct violations, undergraduate, postgraduate. Again, there's conduct violations and there's honor code violations. We dealt with honor code earlier, this is now conduct code. Do you think that we need any further clarification about the two, or you think it's fine?
Meredith, do you think that most students will know the distinction between the two? Like if they've gotten a violation, will they know that it's?
I don't think they will think that through at the time that they're first considering this. No.
I do think it's dependent on the institution that the student's coming from, because in some institutions, honor code falls, well, it's all lumped together, and in some it's not. So it could potentially be confusing, but I think it could be equally confusing if it was combined.
Would it be helpful to like reference one another and to like have some clarifying language?
Perhaps. I mean, honor code typically would refer to academic integrity, whereas code of conduct would be more behavioral. So perhaps.
If that's what we're thinking about in terms of those distinctions, maybe it's worth clarifying for the applicant.
And I do think referring them back to each other is a good idea, so that a student who's confused can
Oh no, it actually is.
not inadvertently fail to disclose.
One way to do it may be to not use the word honor, use the words conduct for the one situation and academic for the other, not talking about honor. Even though schools do have honor codes that oftentimes involve both situations.
You're in conduct code and academic code? I don't know.
My only caution with that would be, sometimes when they're reading the language, it's interesting because we'll get it both sides. They'll say, well, I read honor code violation, so I didn't think that my dismissal from the school because of something academic counted, or I didn't, since it said academic, I didn't think the plagiarism counted. It's odd, but we do get those quite frequently, so.
It varies so much from school to school that the categories are all over the place. I think most institutions design these in their own context. And at our school, technically, if you're smoking on campus, you'd be violating the honor code. But if you read the code in its entirety, you know that there are grave offenses. And it's pretty easy to figure out the relative gravity of the various offenses. But that's just one institution, but it varies from one to another.
Well, for the 4 schools that we have present, I mean, does this proposal of honor code being academic integrity and conduct code being more behavioral based, does that seem to apply to all of yours?
You're asking about our individual?
Yeah, generally.
Since we
Well,
have
I
different
can tell you that, as to our school, we have an honor code, and it
Yeah.
talks about both conduct violations and academic violations.
Oh.
So honor covers both.
Just be one category, code violation, school code violation, parentheses, honor, conduct, et cetera.
Could it be, could we, I think part of my problem is that they're segmented, right? So if we look at them together, it could say something like academic discipline : conduct, academic discipline : academic integrity. And pair them with each other in the matrix, so that anyone, an applicant who's looking at the matrix is seeing them at the same time and understanding that they're.
Would you want to keep them under the honesty, candor, trustworthy, fairness, or keep them under the respect for their rights? We'll probably move it up to that one, right? I don't know.
Yeah, I would say it would be the honesty, candor,
The part that makes this the most difficult for me is the precision with which it talks about, only one occurred more than 4 years ago. And this includes undergraduate schools as well, where there could be an entirely different standard for undergraduate work than the institution that they graduated from to qualify for the bar exam. And there's so many factors that come into play. Even on plagiarism, there are international variations. We've, for example, our school gotten a lot more compassionate with first year plagiarism violations, because with students who come from East Asia, often plagiarism is viewed as flattering a professor rather than a big moral offense. And rather than just, we used to just dismiss everybody for any sign of plagiarism. And we realized that this was extraordinarily impacting a lot of foreign students that just didn't get it the first time. And once there's a major confrontation, then it changes. So peculiar to our institution, plagiarism is comparatively a lighter offense amongst first year than it is in later years. And that's just the way that we worked it out. We don't expect any institution does it the same way that we do. But these factors are so varied by the context of individual schools that when reading, that's nailed down to column 1 is only 1, column 2 is more than 1. It seems like this is where the structure may not be serving our needs as well.
Maybe it's that same language that we use for the criminal stuff that could be helpful, like frequency, severity.
And you could also mirror what the honor code violation part has, if we wanted to, minor violation as defined by the school, serious violation as defined by the school, so it's as defined. So I don't know if that helps or not, but.
Might I say that as to that, we did discuss at one point indicating that additional inquiry is always required. And it didn't end up that way, but at one point that was considered. In support of having it that way, I can say that, depending upon the situation that involves conduct, it could be serious. If it's a matter involving a student, for instance, breaking into the dean's office and using a crowbar to open up a cabinet drawer and then selling the answer to a final exam to half of the class, that's a serious violation. The fact that it might have happened more than 4 years ago shouldn't mitigate it to the extent that it should not be inquired into. It may be that we want to change what the wording that's there to something that would accommodate an inquiry always.
One way of getting closer to the gravity issue is if it's an offense by which the institution suspended the student or applied a greater penalty than that. I think that's better than what we have here, but I'm still nervous about whether this works across all institutions.
And that does sort of, it attaches, you know, how the institution defines the same conduct.
Yeah, for example, if there's an offense by which a student is required to retake a class without even knowing what the offense was, my conclusion on behalf of you that have to review these is the school did not consider this to be a grade violation, a serious one but not a grade one. If the institution suspended the student for a semester, that tells you something about the seriousness of the offense in the eyes of the institution, and I think that merits consideration heavily. And then there's even graver penalties than that. So I guess it's another variable to throw in, is the severity of the punishment.
So you could add in, like severity of the sanctions or / punishment imposed or something like that as one of the factors considered. Do we want to, okay, I guess there's two questions though still up to the group. Do we want to leave them as two sections, leaving the honor code violation under the honesty part and leaving the conduct code under the respect for the rights of others? Or do we want to bring them both under one heading? Do we want to combine them? I think that's the first question.
I would recommend combining them, just on the grounds that every institution aligns these differently.
I think that makes sense as well.
And under the honesty, okay, so with that, so then we'll use the language we had earlier, adding in the consideration of the seriousness of the sanctions.
Okay? So, does that cover conduct code violations, law school too? I think we kind of covered that there. So then we have court sanctions, which is on page 17. Any comments on court sanctions? Basically, it looks like we've got court sanctions and further inquiry is always necessary.
I like the suggested change to that.
Even if it's a discovery sanction? Dealt with fairly quickly.
I suppose.
Professional complaint, non-lawyer. I guess we would like a real estate license complaint or a notary complaint, something of that nature. Any comments with respect to that area? Professional complaints attorney. Again, if the bar doesn't take any action, we're saying seldom requires further inquiry. But if adverse action is taken or there are numerous complaints, then more serious action is to be taken. Any other comments? Moving on to malpractice, non-legal, real estate or doctor, medical, I guess, or notary. Any comments, thoughts on medical, non-legal? Malpractice, non-legal. So, then we have malpractice, actual malpractice complaints against an attorney. And I guess what staff is suggesting that any allegation of malpractice, whether or not warranted, would require further inquiry just to see if there's some basis for it. And again, if there are more than one allegation, then an informed conference would likely necessary. Moving on, we do have other things to do with going through this. Professional discipline, non-legal, professional military. Military is being added to this. Not sure what you're thinking about with respect to military.
I'm sorry, what page are you on?
Dishonorable
20.
discharge?
And often,
Are you talking about dishonorable discharge? Is that what you're?
maybe,
Or
but
like being court-martialed or non-judicial punishment, things of that nature. I guess it just wasn't accounted for elsewhere. And so rather than creating a new carve-out for it, we added it on, but I mean, the group may decide to have its own carve-out.
I would suggest putting it elsewhere. it doesn't seem to fit with the words professional discipline. There are certainly people who are professionals who are in the military, but not everybody in the military considers themselves to be in that category. So I would suggest putting it in its own military.
If we do that, do we have specific language we want to use for the 3 boxes then?
Do we even ask if somebody's been honorably or dishonorably discharged?
We do, yep.
Oh.
We just don't see.
Do we ask if they were registered for the draft or not?
We do not.
Okay. Anybody got any thoughts about what should go in the boxes for military, or you want to just kind of throw that to staff? Okay, hearing nothing, I'm going to assume we're going to throw that to
Can we
staff.
go back briefly to the malpractice allegations?
Against attorneys?
Yeah,
Okay.
on the bottom of page 19. I suppose the mitigating factor favorable determination might include the fact that no civil suit was filed. But my feelings of this overemphasizes mere allegations rather than a claim that rises to the level of a plaintiff filing a suit against an attorney. There may be some practice areas that are just rife with allegations of malpractice. But if no suit is filed,
Well, how would we even know about it if it was just a letter? I mean, you'd have a complaint to the state bar, and we've dealt with that earlier, or you've got a civil action actually filed, but if somebody just writes a letter and says, I'm going to sue you for malpractice, I'm not sure you'd ever tell the state bar that you were told you're going to be sued by somebody.
but is the term malpractice used to describe most of the state bar ever? Or isn't there other terminology there? I get, is the word malpractice limited to civil complaints by client litigants?
I don't know.
A person who practices criminal writs, the malpractice complaints are astronomical. Because once you've run through every last category, the only thing left to do is to complain about your attorney and hope you can go through the whole thing again. And it's not a reflection on the attorney that they are practicing an area where the volume of allegations is high. It doesn't cost anything to allege that your attorney made a mistake. If you actually go through the trouble of filing a complaint, that says something. Although if it's dismissed early, that doesn't say as much. I'm not sure that nuance is really covered in here.
So in the writ context, are you thinking of ineffective assistance of counsel allegations?
Yeah, but
Because I would think of that as distinct from a malpractice claim. And I know what you mean.
Yeah,
You're going to
there's one
include it.
exception. I don't know that this, is it that informative that clients have complained about malpractice that have never filed suit?
Or you could say that.
If we find out about it,
What about like formal allegation, is formal, so that way if it is a complaint filed with the jurisdiction or a complaint filed with the court, I mean, we could specify that if we want to, but maybe formal is.
and remember, this is just to decide whether we're going to say, hey, about that thing. That's an additional inquiry.
Because I think this does speak to Jim's point that like if they just send an email, you know, to the attorney that I'm gonna sue you for malpractice, like that's something that's never needed to be disclosed to us unless it resulted in some other action. So I think that's where we were going.
Maybe a
That's where the
formal
train of thought
complaint to a third party or something.
So, and that suggests that it's not going to be a problem that arises very much. But the issue is still here. And I just wonder if an allegation that is never backed up by actually filing suit and pursuing the case somewhat isn't a matter that's generally so low grade that it shouldn't be in the first column of additional inquiries seldom necessary. It's definitely meaningful if somebody actually invests in their claim enough to file a suit. But
Although we could, when we send out letters, you send out letters saying, do you recommend this person to be an attorney? Occasionally, letters come back to say, absolutely not, this guy committed malpractice in my case, and you should never let him be an attorney. So there are allegations you guys get of malpractice that weren't civil actions or weren't filed with anybody else.
Yeah, it's interesting, it's relevant, the interaction between the disclosure rules and then the moral character determination. So, you know, depending on what's on the moral character application, we'll find out about certain malpractice allegations.
I can think of another example. An attorney who's in the practice of suing clients for non-payment of bills has an extremely high percentage of allegations of malpractice. I think that's almost habitual.
And so that may not be, oh, I'm sorry.
I was gonna say, but I think we want to err on the side of people disclosing this. I mean, you gotta think about consumer protection at some point. I mean, I'm sitting here thinking of all the times that people don't say anything because they've been taken advantage of to the point that it becomes criminal. So I think the openness of this is just to open the door to an inquiry, and it's better for them to disclose. And if it turns out to be nothing, it's nothing. It's I'm a criminal, I did a lot of criminal defense work, and I did a lot of writ work, and I have lots of claims of incompetent or ineffective assistance of counsel, but they're unfounded, whatever. None of the writs were granted. I think it's a simple explanation. But to try to narrow this in a way where people feel like, especially attorneys that are practicing somewhere else, and there's the word malpractice or anything ineffective already associated with them, I think they need to disclose that and then make a determination of its relevance, aggravating, mitigating factors, all of those things.
So the consensus of the group, do you want to leave the 5 boxes as they are now? Okay,
Yeah, leave all, let them explain.
thank you. On military, we, I think, discussed that we wanted staff to kind of break that off and do something separately with that, and left it to staff. And we've got professional discipline attorney.
May I say as to military that I'd be willing to help with that wording. I just sketched some out that I could offer now, so if you'd rather have me think about it. Since I was in the military, I was a judge advocate in the military, so I've got, I have some words in mind.
Great.
That would be awesome. Should we hear that now?
You want to?
Well, I was going to say for the first column, it could say, it could be additional inquiry seldom necessary if the conduct did not result in administrative discharge, non-judicial punishment, or courts-martial guilt verdict. And then you could use a variation of that for the second column, meaning that additional inquiry may be necessary if the conduct resulted in administrative discharge, non-judicial punishment, or courts-martial verdict. And then same for the next column.
For the third?
For the third. And then for aggravating and mitigating circumstances, there are probably a few, but I'm guessing they would pretty much match up with what you'd use for regular criminal conduct, civilian criminal conduct.
Thank you.
Thank you. Moving ahead, not wanting to rush, but want to keep moving on. Professional discipline attorney, page 21. Anybody have any comments, particularly about the aggravating and mitigating column or any column? What do you mean by any professional discipline as an attorney? You mean any disciplinary
Action.
Action.
Discipline imposed.
So it actually imposed, the discipline imposed. Okay.
Maybe we should make that more clear.
Okay, I'm going to move to page 22, to unauthorized practice of law, or what's referred to a lot as UPL. And I guess any allegation of the unlawful practice of law requires at least further inquiry, and in many cases, an informal conference, because we take it seriously. Any more comments on those cells? Okay, so I think we've gotten through the decisional matrix.
Can I just ask a question real quickly, James, sorry. Under UPL, it's any allegation, but under professional discipline, it's just professional discipline that's imposed. One feels more like you want a broader amount of information, and one is only as if there's discipline that's actually been imposed. Is that, am I hearing that correctly?
Well,
That is, but we also do have, sorry to
No.
interrupt you, but we also have the professional complaints for an attorney, so if there's a.
So those would come up then. Okay, great. Thank you. Just want to be consistent.
and many times the unlawful practice of law came to the committee when I was involved with it, when there wasn't any discipline being taken. It's just kind of like they appeared and we looked at their record and said, wait a second, you've been practicing law for 4 years and you're just coming to us now. How do we deal with it? Okay, so, sorry. So unless anybody has suggestions to go further, I'm going to go to, can we do, the moral character statement guidelines, which is a whole other subject, which you got me listed to doing, but I'm going to throw this to you. Is that okay?
Of course.
Because it's greatly done and you get credit for it.
So we made a few changes since the last version, but taking in some of the feedback, so hopefully you've had a chance to review it. If you have any feedback now, we can go through it section by section or just take it generally. But one of the asks was also, so when we were formulating this and then we have the matrices, we had the presentations that David did where he discussed possible language for certain topics. I think as we saw, some jurisdictions have this, some don't. So I think it's really where you feel it's necessary. For example, like maybe we do need it for UPL so the applicants know. We do find a lot of them say, well, I'm not going to court, so I'm not practicing law, or they don't think about the appearance of it, part of it. But maybe for criminal history or something, just for example, we don't need it. So it's really up to the group which sections you want to use, how much of it's necessary, knowing that we have the matrices and it'll all be easily accessible to the applicants.
So which we're talking about now, the sample language?
So we can either take, so we can go through the statement section by section, or if anybody just has any general comments, and then we can jump, I think, to the sample language to see what folks think we need.
Yeah, maybe that makes sense. First go through.
This is the 4-page document, right?
3-page document, I think.
It's 4, there's a page on the back.
That's right, blank.
I don't think we're doing this.
Right there, read it.
This is 4 pages.
Oh, so the statement and guidelines right now.
I think Tara was suggesting we go through this
Okay,
first,
I'm
since
sorry.
it's sort of broader, and
And then we
then,
can jump to the language.
and then look at the sample language.
Okay. So the moral character determination statement and guidelines.
And this would ideally take place of the statement and the factors that are on the website now, so this should hopefully provide some more clarity into not only why we're looking at someone's moral character, so the purpose and standards, and then as well as like how the process works, and then the factors, which is where the matrices comes in, so. Does anybody have any comments on the mission statement, I guess, or the purpose and standards of page 1?
I'm sorry, what is the and others refer to?
Where are you referring to?
In line 2.
Is that referring to the MPA?
Permission to the state bar and others.
I think that's what it was, so, I mean, we could change that to limited admission or something of
We were
that nature.
Thinking of, foreign legal consultants, registered in-house counsel, I guess technically they are being admitted for, in a limited way. It's not exactly the same as becoming a fully licensed attorney. That was what the and others was referring to, I think.
I think that's very confusing.
To the state bar and limited admission, or what is it?
You know, maybe admission to the state bar, it encompasses any sort of admission.
Because we talk about the registered in-house counsel and those programs down below too, so maybe we can just strike that part.
Yeah, and by the way, is the admission language correct now that we're licensees and not members? We can talk about that, yeah.
Are we licensed to practice law rather than admitted to practice law?
Well, we're admitted and licensed to practice law in California. That language actually appears. But are we admitted to the state bar, Amy?
Yes, I know that the semantics changed when
Yeah.
we moved from license, from
Member
members
to
to
licensee.
licensee. But yes, you're admitted to practice.
Are you admitted to the state bar?
To examine all applicants for admission, yeah, it is admission, that's what the rules state, so.
Okay.
Bring forth for admission to those applicants.
Some of the VMP code updates have said for those seeking admission and a license to practice law.
Yeah.
So you could word it the same way.
You could say that. Sorry.
And we're getting rid of the end of it.
So are you recommending that it say, for those seeking admission to the state bar and a license to practice law shall be uniform, consistent, and transparent?
Yes.
Yes, I like that. Then it covers the limited individual process.
Yeah. And yes, the state bar uses the Oxford comma.
Some of us. Is it? Oh, all right, it's apparently in the style guide. So anything on the purpose and standards? Some of this was taken from existing language, or the existing language and then kind of beefed up. Some of it was reworded, so.
Do we have the previous? I mean, I guess.
Okay, forget it.
Yeah, which ones do? They have a state.
There's no questions on that part, we could go to the process and, there's any feedback from you there?
We have previously. It wasn't concrete one way, this one. So are we looking now at the specific, the second document?
Yeah, down on page 2, about halfway down process below.
Oh, that's where we are, okay, thanks, sorry.
And actually, I think we should probably take that out because, yeah, because it sounds like it could refer to Pro Hoc Vice, which they don't have to do all of that.
I'm excited to go to those, I think it's fun.
That's true, yeah. Or, well, oh, I see what you're saying, sorry.
we're in the process section. At the top of page 3, it says all questions on the application must be answered accurately, which makes sense. Is accurately the term that is used throughout, or is candidly, or I just want to be sure in all places there's consistency.
Yeah, and I suppose there could be an inadvertent inaccuracy.
I believe everything, the language is in the instructions, but I'm gonna pull it up right now and just verify.
Maybe some kind of good faith language. I might forget how long I lived in that apartment 15 years ago.
So the application, the lead-in says, it says both truthful and then later it says answered accurately, so.
I'm not opposed to accurately, I just want to be sure that it's consistent in the other.
Okay, so that sentence in particular, all questions on the application must be answered accurately came from there's like two, there's an actual instruction and there's an instruction in the application, so that came from the instruction in the application itself.
So we speak of a candor trap for people who've been convicted of certain crimes and don't put down something that maybe happened a long time ago. They went through court so quickly they didn't even understand what happened to them when they were in court, that they were convicted of 2 things, not 1, or that they got something expunged and their lawyer told them that they don't have to include it, or things like that. So I would be in favor of some kind of good faith language so that we're not completely, if someone omits information inadvertently, like that they're not, doesn't completely penalize the application.
Yeah, although note that this sentence is just speaking about when the application is considered complete. And in this context, complete is a term of art that sets off certain deadlines. And so even if they, in good faith, answered a question inaccurately and we discover it's inaccurate, until it gets fixed, it's
So
not.
do you want to say completely then?
Well, complete is what we're defining.
And we do have on the matrices the mistake error in the additional inquiry seldom necessary box for the omissions part.
That's true. Maybe the matrices capture it, Debbie? In the candor section? Or do you think?
Go back.
I mean, maybe it would be more clear without the semicolon if it just said an application will be considered incomplete until all, until all questions are answered.
Or all information is gathered, because it could be you gather the same information via another question or something like that.
Yeah. Something.
Or maybe completely inaccurately. I'm thinking the accurate word is in there because, for example, I don't know why, but it asks for your parents' names before marriage, and a lot of the times we'll get the mother's married name versus the maiden name, and so it's something that the applications are made incomplete for, and we have to get that information, but maybe complete and accurate would be more precise.
So the matrix is really speaking to omissions that are on other applications.
Or the moral character.
I think we fell under the licensing agencies. I mean, we could specifically call out the State Bar of California, but. So if there's nothing else in the process, then we can move to the factors. And then this is where that sample language goes in. So we could list, essentially when it says issues relevant to moral character determination include but are not limited to, you could list all of them, you could list just the ones that we're gonna give the extra descriptive paragraph for. I guess how much information do we think is necessary here? We do refer the applicants to the matrices for more information, but obviously that's limited in the description that it gives of specific items if we wanted to give more text.
Yeah, this just goes to transparency and providing as much information as possible. But if you all don't think it's necessary, then that's fine too.
So I don't know if we want to do it this way, but we could go to the sample language and just go down the list and say yes or no, or if you want to call out certain ones you think are unnecessary.
You talking about the issues relevant?
So
There's two. So there's the issues relevant, so we can either list essentially all of the categories that are on the matrices themselves, or you could list some of the ones that we're just going to give descriptions for. So there's a couple different ways you could do it.
yeah, you could say issues relevant to a moral character determination are reflected in the, matrices or whatever they're going to be called.
And the bullet points may not be necessary. You could just strike them and say, give the additional language.
Yeah, and then it could say something like, following some elaboration or additional information regarding some of the key issues or something.
And I would maybe also refer that it's based on case law. So that they know that like these standards come from, like you're bound by what the court has told you,
Yeah.
right?
And yeah, Tara had a good example. A lot of people don't understand that in California, it's one engages in the unauthorized practice of law by holding oneself out as an attorney, even if you never actually practice. That's just one example. So kind of giving people a heads up.
And that vein, what we came seeing before is even listing yourself as an attorney on a LinkedIn page, just using the term attorney next to you is by definition the normal practice of law. I didn't know that until I got in this committee, but do we want to say something like that or not?
Well, that's the question. So that is, if you look at the sample language, that is incorporated to the language suggested for UPL for the unauthorized practice of law, holding oneself out. Oh, but you mean specifically giving an example like identifying yourself as an attorney
on your LinkedIn page.
I like the high level of
Okay.
nature of like what you have on this document for all the different categories. I don't know if you need them all, but I don't see a problem with including them all. Like I actually think it just aids in the spirit of being transparent and providing some guidance to applicants.
As to the part of it that refers to honor code / student conduct violations, it seems that we should change the word honor code to academic / student conduct violations so that it's in line with what we talked about earlier.
Good point, and we should make sure that the other ones, if the group made changes in the matrices, we should make sure that there's consistency.
Is there any paragraph that anyone feels should not be included, or, so Debbie said she would agree with including all of them, so does anyone think otherwise? If not, they can definitely all be added in.
I like the rehabilitation paragraph. I was, struggling a lot with that because we talked about the student who cheats on an exam or plagiarizes or commits another offense that wants to be rehabilitated. And I think it makes it real clear on rehabilitation remorse what the standard is.
And I was actually going to suggest, and I know this is, I am staff, and this is staff's recommendation, so I have no right to make another one, but that rehabilitation, instead of being one thing in this list, it somehow has to stand alone or be highlighted because it's such a crucial part of the inquiry. It's not just another act of misconduct. The rest of these refer to acts of misconduct, right? Whereas rehabilitation is sort of a separate category. I don't know how that would be done, but that was a thought.
As to the wording that's listed for remorse, is it wording that's appeared for some time now?
That it does not demonstrate rehabilitation?
Yeah, but I ask because it talks about full acknowledgement of wrongdoing, but then it says often is a necessary step. It doesn't say always.
Yeah, that's right from a Supreme Court case.
And I'm in favor of it being the way that it is, but I was under the impression that it was always required, full acknowledgement of wrongdoing.
Well, the idea there, so, is the civil disobedience example, Martin Luther King Jr., it might not be appropriate to acknowledge wrongdoing because you might not feel that what you did was wrong.
Does it also get at, like, if you feel like you're innocent?
Right,
Like, I mean,
right. Oh, yeah, I mean,
that
I
I
guess.
think of as differently than the Martin Luther King example. Like they caught the wrong guy.
Although I guess it is sort of captured in, if you've already gotten to the point where you're looking at remorse and rehabilitation, and that is predicated on the fact that you did in fact do something wrong, then it would be always necessary. I see your point. But
I'm happy with
that's
the word often, that's for sure. I just wanted to kind of clarify as to whether or not this is a change or
I don't think it,
the same as it has been.
I don't know that it's specifically spoke to before, but I can look real quick.
I can also find.
I was trying to think, for organizational purposes, I kind of understand, since we want to highlight the rehabilitation part, rather than putting it like towards the end of this list, so we have the heading factors and conduct relevant to moral character determinations, then the paragraph, so we could just have the paragraph then that discusses rehabilitation, and then below would be essentially the definitions or the expansions of the actual misconduct topics. Maybe that highlights it better.
But there have been situations where the individual applicant just said, I didn't do it. Yes, we had sexual relations, but it was consensual. And I'm never going to say it wasn't consensual. And you say, well, then we have to look at other factors. We're not going to say you have to say it wasn't consensual, or that you proposition somewhere with her. I agree. I think the office.
And
Most times it is clear that they did do it, though.
on the website right now, between the statement and the factors, the only place that remorse actually is stated, it says, bad character witnesses alone will not adequately show rehabilitation or remorse. So this would be new language that we're proposing from the court case, though.
So I guess I would ask the schools, does this language help you maybe figure out better how you might approach the student who comes to you and says, I have this problem, how do I get to rehabilitation so I can get my license? So you can have a program in place or talk to them. Do you feel you need more information than we've given you here?
I think it's helpful, absolutely. The definition for rehabilitation and remorse are helpful.
And I would agree that it's helpful, but I would also counter that it's not the school's responsibility to set forth a program for rehabilitation.
Not responsibility, but certainly you can if you choose to.
So it sounds like so far everyone is on board with keeping the language. On the last page of the statement of guidelines, page 4, we just have 2 other sections, so further investigation of formal conferences, and then there's a small paragraph about the decisional matrices, but based on some of the information today, we could probably add a little bit there. Does anybody have any comments on those 2 sections?
Would this be where they would know that they can have an attorney present, that an attorney can't speak? What does this come up? Does that come up somewhere else?
So we say that in the informal conference letter, but we could add that in since we're discussing informals. And it's on the rules too, but we could add it here.
And then just from a practical perspective, what order will these be in? Alphabetical, or, because it seems like you want to make it easy for an applicant to navigate.
For the paragraphs.
The sample
Yeah.
language paragraphs.
Yeah. There should be some rhyme.
Some rhyme,
Yeah.
yeah.
I mean, maybe alphabetical makes the most sense, then there's hyperlinks to it, I don't know. Like,
Well, I would put criminal history and community supervision together.
And yeah, we should, hopefully they'll all be hyperlinked from the matrices also, when you're going through, you see something hyperlinked, you just click and it goes through elaboration.
So it seems like candor, rehabilitation, and remorse are all sort of in a similar vein, right?
so we could pull all three of those ones out, and add them under that initial paragraph under the factors if we'd like. If that calls more attention to them.
Like cooperation with the moral character process doesn't kind of go with anything. Because it's not,
If we wanted, Meredith, they could be in alphabetical order, and then if there is a closely related one, just a parenthetical at the end with a hyperlink, C, blah, blah, blah.
Yeah.
And then you just click.
it might be that criminal history and community supervision go together.
The system has detected that a minimum number of lines are connected to this conference. Do you continue?
The moral character process comes in the middle.
We will simply delete that.
We were just talking about whether or not all of these go in what order. And then
And the part about the cooperation with the process could be taken out and put in the section beforehand under process, just putting that at the end is kind of a reminder to the applicants then.
That's true. Yeah.
Please forgive me if we've addressed this, but I know there's the emphasis throughout on candor and the need to disclose, and how material omissions can be problematic. How will failures to disclose to law schools be treated? So like our application says you must disclose these same things, right? And frequently a student will come to me only when they're filling out the moral character application, and they'll say, whoopsies, I forgot to disclose this, I need to disclose it now. And we view that as a failure to timely disclose because they're given many opportunities, including the grace period when they matriculate. So where does that fall in terms of the moral character evaluation?
Well, that,
How would I counsel a student in that situation?
that would be included in the matrices under omissions, right?
I think,
No.
I'm trying to think, so if we have students in those situations, I mean, our typical question is going to be, you know, why didn't you initially disclose it, what prompted you to disclose it now? And then if the school took any action. So we do view that as serious as well, so, really they'd have to explain why, and then we'd look to see, okay, well, have you done anything since then? So the rehabilitation part, so some of them, you know, they've offered to go speak to the 1L classes, or they do ethics school or something like that, so.
The ones who say, I don't know why I did it, don't go very far, where they say, yeah, I did it because I was afraid I wasn't gonna get admitted if I told them that I stole a belt when I was in high school or whatever, so. Certainly acknowledging why you did it rather than saying, you know, I don't know why, because they don't know why, it makes a difference, and then what they do with it.
And would whether the school took any action on the basis of the omission be a factor?
Yes, because typically, I mean, I think from what we see, if the school does take an action, it would be either like an honor code or a conduct code violation, so then we treat that as well as another item of concern, so.
Because I can imagine that is handled pretty inconsistently from school to school.
Yeah, so in one case, it's the underlying conduct that matters, not really what the school calls it or doesn't call it. But if it is a violation of a school code, well, that was a code the person was supposed to be following, so that's an additional act of misconduct, you know what I mean? Even if schools have different codes that make different conduct either a violation or not, presumably the code that you have agreed to follow is the one that you should, is the idea at least.
But the reality is they don't agree to the code until they've been accepted and enrolled. When they're an applicant, they may argue that they're not, they weren't under any particular obligation, whether there may be a moral one, a general moral obligation to tell the truth.
Yeah,
It seems to me even that's relevant.
Well, the application would hopefully,
right.
our law school application makes clear that there's an obligation to accurately answer the character and fitness questions, and an ongoing duty to report if their answers to those questions change.
And if they weren't under the code, then presumably there wouldn't be a code violation found. So it wouldn't be relevant, right? But it would still be relevant to us as far as being an omission from the application, because certainly the application instructions are going to say, fill this out.
Could be relevant to whether or not a person is generally honest, whether they were violating the code honor code section or not.
Yep. And rehabilitation matters a lot. You know, there are people who go into law school and the sort of gravity or importance of some of these things has not quite dawned on them when before they're even a 1L and they're filling out applications, and then they go through law school and they come in and talk to us, and it's very clear that they now understand and they likely would not do that again, you know.
Is there anything else then on statement and guidelines or the sample language? So we'll put them together and then bring them for approval next time as well.
Go ahead, Larry.
No, I was also gonna say that last paragraph on the 4-page document, the one that talks about the matrices, now that should be, again, this is a design thing. We want people to read that. You know, just look at the matrices, understand, you know, what they are and what they are not. You know, there's examples, but it's not everything, blah, 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 blah. You know, I mean, to some degree, you gotta underestimate the intelligence of the people reading this.
I wouldn't say that. I would just say that, like, there's a huge value in how information gets presented and in how people receive information. So I wouldn't, and there's people smarter than me who think about that, right? That,
I agree, it's on the designer, it's
there's
not on
design
the user.
people, right? Like, And that I think is important in something as complex of information as you're trying to present and how nuanced it is, so, yeah.
Okay. Going back, I don't think we actually had a final motion and vote to accept various comments and suggestions with respect to changing the decisional matrix after lunch. So do we want to do a vote, or we just want to say we concur that those discussions are basically agreed to by the working group as a whole?
Can I just ask specifically, so, I forget, was it Myron, Michael, one of you had a great suggestion about in this statement to, regarding the, age of issues, what was it,
Severity.
Frequency. So where are we gonna add that in our missions, or in the statement and guidelines? Or would that be under,
We could then add a sentence to that under the factors and conduct, maybe in the introduction paragraph, so it's upfront as well as we'll have it in the matrices themselves.
so in this mission statement or in the proposed standards section? I'm not sure where you would.
So I was suggesting page 3, the factors and conduct relevance when
Oh, yeah.
for the consumer.
Okay. So the statement would be, I didn't write it down, so hold on, let me see.
I have length of time, severity, and frequency. Was that the phrase?
I think
I've been being
it was Myron that was your idea.
That's
I guess the.
Remember we were talking about
This
that
whole
language.
situation, there's no active misconduct that is outside its outside the injury from taking the positive conduct. So what was it, length of time?
Length of time, severity, and frequency. And I guess what,
And frequency will be taken into consideration? Will be given full consideration? I don't know. I'm just trying to add it on to that last paragraph. Automatically, so there's no act of misconduct that in and of itself automatically disqualifies an individual from obtaining a positive moral character determination. Length of time, severity, and frequency are all factors that will be taken into full consideration. Full consideration? Something like that? Just taking a stab. If somebody else has a better suggestion or staff comes up with better language, but I agree that would be the right spot to put it. I don't know if we have to do this individually or not, but I think it's a good idea to add that in the statements and guidelines. And were we gonna put it in the matrix also? Was that the recommendation? I don't recall. Yes? Yes.
So I guess do you want to make a motion on both the matrices and the statement and guidelines too?
Okay.
Recommendations?
If we're ready, do we want to have someone make a motion approving the recommended changes to the statements and guidelines and to the decisional matrix that we've discussed in the meeting? So we'll Barry make the motion, anybody second? Second. Any further discussions or any, want to break out a particular item? Having heard none, all in favor?
Aye.
Any opposed? So I believe that then leads us to determining next steps in the working committee group and propose future topics and discussing our next February 20th meeting, which I understand is in San Francisco.
So I think the question we had out to the group was, a couple of meetings ago, we had talked about doing these proposed best practices for the law schools. Is that something we still want to to do, we can, if so, then we'll put it together in a document, we'll send that out, and that way we can finalize it at the next meeting. I think the decision wasn't made when we brought it up at the meeting itself.
I like that suggestion.
So we'll do that then, and then, so these are very similar slides from before, and then we just have our target dates that we're working with, so, if everything goes accordingly, then this would be implemented by staff the later half of this year, so.
Any other comments or things you want to raise in the meeting today, Larry?
Yeah, I don't know, maybe we do it now, or maybe we do it at the next meeting, but I thought, we just spent this whole meeting like sort of going through piece by piece. And it's important, I always think when you're done with a project like this, to take a step back, and look at the forest instead of the trees. So the question being, do we feel like we accomplished what we set out to do?
Right now?
Huh?
Right now?
Well, no, I mean, you don't have to answer that now, but I mean, I think that's a good question to ask, maybe that we talk about that at the next meeting.
So that's a good suggestion, because there's one more meeting left. And I think that when the group first started, you had a list of objectives. I think bringing those up and checking how much these work products correspond with that, will do exactly that.
I'm wondering, like, when you're seeking input from the Supreme Court, and are you thinking that you're gonna have already had the materials designed by someone?
Probably
when you present it to all those various stakeholders?
Probably not.
It will probably be on paper.
Yeah, we'll probably have these work products and have to highlight them, that sort of.
And so then is it realistic that you're gonna actually get this stuff up on June or July? Working with the designer?
Yeah, I mean, if we start gathering that personnel, I mean, in terms of the format, I mean, the matrices will probably be in that format. It's a content that's probably gonna change, so I think we could do it by June, but I think to assume that we'll have it by March, I don't think that's that feasible. To have it in a design shop and then to the Supreme Court by March, I don't think it's gonna be that easy.
Would any annotations explaining this be a separate project after this plan has been approved? Or would all of that need to go to the Supreme Court prior to their consideration? So we've talked about explanatory notes to include a lot of this.
I think they're gonna be included in this product, right?
Yeah. You mean as far as the paragraphs about topics, like the unauthorized practice of law? That document?
The explanation, yeah.
Yeah, that'll be part of what the Supreme Court reviews.
Yeah. Or everything that we've talked about, like the definitions that have been included, and we have like 3 different sources for that. All of that will be part of the package that goes to the Supreme Court.
Yeah. Yeah, the court has to approve.
Okay. I'm unable to attend next time. We got our university board meeting that day, so sorry to miss you all.
Well, thank you for joining us and stepping in to fill the role. It's helpful.
Yeah.
Okay, so is there anything else people want to cover today? If not, we'll get these a few days before the next meeting more, and we'll review them and be ready to talk about them on February 20th. Okay, thank you.
Our meeting time next time will be 10:30.
Back to 10:30.
10:30 next meeting?
It's a Thursday, I think.
Thursday.
Same food? If you want to eat this. Larry?
Larry?
Do you want the same food or fajitas?
Next week.
Oh, I thought they were.
Whatever you want to do.
Were you